Right, good morning and welcome to this year's BEG conference on UK and European law in the new UK-EU partnership. It's my honour to welcome you as chairman of BEG to this, our second online conference in the history of the group, but part of an unbroken line of annual conferences stretching back to the 1980s. Although we're all familiar with Zoom, a few pointers about the technology today. This conference is being held in a webinar setting. The chair and the panelists for each session are going to be visible and audible, and the other conference delegates are attendees and are not visible or audible unless brought into the spotlight by the host. So whether you're muted or not muted, if you're not on screen, you can rest assured that you're not being heard. The conference is being recorded. It's being recorded as speaker view. So if you're not the speaker, again, you will not be in the recording. The first three speakers of the day can be seen at the top of the screen alongside me. And they are our president, Lord Lloyd-Jones, the former judge, Christopher Vajda QC, and Clare Brodie, and I welcome you, and as indeed I welcome everyone. As the panels change during the day, I'm going to move people in and out of the spotlight, and you'll see my technical skills tested, no doubt, to the full. Then they will be switched to attendees, and the next panel will come, and so forth. You do have the chat function, and I see someone's already started to chat. Hello. And you can all chat with each other, either directly, privately, or publicly with everyone. For questions, there is the question and answer button towards the bottom of your screen. So if you have questions for the panel, please try and use the Q&A function, because it won't be easy for the panel chairs to identify the questions in the chat on the side, and it'll be easier to use Q&A, and they will be picked up and then read out, always, if there is time, at the end of each session for answers. The format of the day is going to look like this. We have the morning session until 11:30, when there will be a break. Then the first panel, a lunch break from about 1 to 2, and the afternoon panels from 2 to 5, with a break, a short break at about 4. And the conference is due to finish around 5 p.m. And there is, of course, another important European event happening today, which is Eurovision. And I'm sure all our conference delegates wouldn't want to miss that. So we'll finish in good time. So much for that. A few words on the work of the Bar European Group and the Bar generally in relation to Brexit. The consequence of Brexit has been that there's been more European law and European related issues than ever. The Bar European Group has been working with the Bar Council and with other groups such as the Future Relations Working Group, the European Committee, and the Bar Council Brussels office on all of these matters. And we have had regular meetings with both the UK government and various EU institutions and bars, and much work remains to be done. We will hear some of this in the session on cross-border services at 3, when our Bar Council Brussels rep, Evanna, Fruithof, and others will be talking about this. Speaking to the House of Commons European Committee this week, the responsible minister, Lord Frost, said that his 3 main priorities were Northern Ireland and the protocol, getting the overall relationship with the EU on a decent footing, as he puts it, and that it would be a bit bumpy for a time as well as identifying the opportunities of Brexit. So that's the government position. To say it might be a bit bumpy might itself be an understatement. Lord Frost himself gave an important example, which is Gibraltar, that the mandate for the negotiations ought to be ready this month and will then have to be signed off by the European Council, with negotiations starting maybe around the end of June. Another important area of dispute is data equivalence. Yesterday, as some may be aware, the European Parliament voted against the EC's draft adequacy decision, pending amendment, in light of further changes and guarantees on the UK side, mentioning various steps taken to change the law in the United Kingdom as undermining confidence. And the Parliament said that it takes the view that by adopting implementing decisions which are not consistent with EU law, without having addressed all the concerns in the Parliament's resolution, the Commission is going beyond the implementing powers conferred on it, and therefore it objects to the implementing acts on data equivalence on the basis that they're not consistent with EU law. So there's plainly a lot of diplomatic work to do, externally and internally, including by organizations such as ourselves. One aspect that we've been focusing on particularly has been the Lugano Convention. And there was a very lively discussion about it, if you remember, at our September conference. Now that the EU has left the UK has left the EU, now that the EU has decided to leave us, without any civil jurisdiction and judgments provisions in the TCA, there is now the national law of each state that governs conflict between the UK and the EU member states, and we have our own. We've fallen back, as it were, on our own national law in the absence of Brussels. And the effect is that there is no automatic recognition of judgments, and jurisdiction is, to some extent, the way it was pre-Brussels. Now, the UK government line is this is no disaster. And whilst that may be so, we do consider that it's undesirable from a rule of law perspective and also access to justice point of view. The Commission's reasoning is that the EU rules on jurisdiction are part of the single market. And if you're not a member of the club, you can't benefit from its rules. But we don't see why that should be so, because the origins of this scheme are in a convention, in the Brussels Convention of 1968, which was the precursor to Brussels I. And thus Lugano 2007 was intergovernmental. And the origins of the scheme predates the establishment of the EU, let alone the single market, at least as far as the UK is concerned. So we have been working on this, and we've also discovered a ministerial recommendation of the Council of Europe, so that's all of the countries of Europe, which recommended in 2016 that Council of Europe members should apply for accession to the Lugano Convention. And it appears that neither the EU nor any member state has ever challenged the legitimacy of that Council of Europe recommendation, which seems to us also an argument against the Commission's view that this is a single market measure. So that sits with the member states at the moment, Lugano, and so we will watch this space. But we are active, perhaps more active than the beggars needed to be in the past, in talking to other stakeholders about these sorts of issues. And we shall report back. Now to the conference. And before I ask our president to open the conference, there is one matter that I wanted to raise, which is that in every conference we've had so far, since she became Advocate General, Eleanor Sharpston has been one of the speakers. And I'm going to invite her onto the opening panel. Oh, I've invited Edwin as well. Sorry, I'm just going to move Edwin back. I've invited Eleanor onto the panel. Eleanor's, I'm sure you won't mind my explaining, recently undergone a major operation and is recovering well, happily, and is going to say a few words if we can manage to go live to Luxembourg for our own Eurovisionary. Leo, are you there?
I am indeed there, Philip. Can you hear me?
I can hear you. I can't see you.
Well, that is because I have no way of making myself visible because the usual button isn't there.
Well, I'm going to, this is a useful test. I'm going to make sure.
We both know that I am technologically challenged, by the way, so any cock-up should be laid at my door rather than at the door of the chairman. I should like to make that very clear to all attendees.
I doubt that very much. While I work on that, here we are. Are you now able to activate your camera?
Aha. And now I'm allowed to start my video. You are definitely impressive, Philip. I'm deeply, deeply impressed. Good morning. This is a very brief cameo guest appearance courtesy of the chairman. It's a joy to be briefly in the company of so many old and very dear friends. And obviously the pandemic has changed all our lives. I thought I would mention to you that even that bastion of tradition, the French language, has had to adapt to the pandemic. I've been doing a bit of teaching via Zoom for the Université Libre de Bruxelles, and I've discovered that in high-flown, respectable French, one now refers seamlessly to en virtuel and en présentiel, although I confess I'm not entirely sure how you spell the latter. You don't need me to tell you that we're now watching the tragicomedy farce that is Brexit play out. As a good half Irish woman, I'm of course worried about the Northern Ireland Protocol, about its implementation, about the real possibility, as it occasionally seems, of the UK not keeping its international word, and the implications of that, both for the Good Friday Agreement and peace in Northern Ireland, but also, as a matter of fact, for UK credibility as a trustworthy partner for international trade deals. That seems to me perhaps to be rather important. Now, you each have your own experiences and stories about the story so far. What's reaching me from various sources is that the English Bar and the members of the Bar European Group are reacting with their customary intelligence, their creativity, their resilience, possibly sometimes posing as the Irish Bar, but you're all looking at what's happening and you're all managing to take matters forward and your practices forward. And I'd love to say, and I really mean it, good for you. That's exactly what you should be doing. As for my own story, well, as Philip's indicated, I seem to have been exceptionally careless because I have both lost my dream job ahead of the end of my mandate, and I have had a repeat of the rare bilateral multifocal kidney cancer that I thought I'd seen off in 2010, 2011. The first has led to the affair Sharpston, which I'm not going to talk about. It's a pure issue of principle. There's no money claim. And the question is simply whether it's a good idea or perhaps not a good idea for the rule of law if you can sack a serving member of a Supreme Court in mid-mandate by political means, for political reasons, without judicial redress. But I would like to say a public thank you to Nicholas Forward QC, James Flynn QC, Hugh Mercer QC, and John Robb for collectively acting as Sir Galahad in this particular matter. As for the latter, well, I'm delighted to report that after round one, the unwanted house guests have been removed from one kidney, which I have affectionately christened Castor, by a brilliant surgeon in Leuven, and that round 2, which is to do the same with the squatters on the other kidney, Pollux, will probably be rescheduled fairly shortly. After that, I look forward to trying to get back to being my usual tediously bouncy self. And I shall obviously need to reinvent myself, shan't I? Perhaps as an eco-warrior, who knows? But for the moment, as you may gather from my shifting about, given that I have a 20-centimeter hole in my side, sitting still in front of a Zoom screen is not actually very comfortable. So with great regret that I can't follow the conference, I'm going to bow out now. I wish you all an excellent conference, and I do hope, I really do hope, to be with you properly for the next event. Philip, thank you very much.
Thank you. It's lovely to see you, and we wish you all the best. And I'm delighted that you had this opportunity. And can I point out that there's an excellent article about the affair Sharpston in our latest edition of the European Advocate, which is also the last hard copy edition of the European Advocate before it goes virtual. So if you're a member of BEG, you should somewhere have received this in the post. So thank you, Leo, and
thanks.
Gute Besserung.
Vielen Dank, Philipp. Vielen Dank. Alles Gute.
Right. With that word from a former chairman, can I hand over to our current president, David Lloyd-Jones. I don't think, David, you need much introduction, but David, of course, is a Justice of the Supreme Court and a former chairman of BEG, as well as having been a presiding judge of the Wales Circuit and chairman of the Law Commission, and has been on the UK Supreme Court since 2017. David.
Thank you, Philip. Good morning, everybody. Can I just say, as a footnote to Eleanor's cameo appearance, that it's great to see her in such excellent form this morning, and I'm sure we all wish her a rapid and complete recovery. I'm sure she'll be fighting fit again very soon. Well, good morning, everyone, and welcome to the Bar European Group's Spring 2021 conference. It's excellent to see that it's so well attended. I can see 76 participants at the moment. And it's a great pleasure to see so many old friends here, including those to whom John Laws used to refer as the usual suspects. But I should also like to extend a particular welcome to those of you who are attending a BEG conference for the first time, among you this year's scholars, of whom there are 11. We hope that this will be the first of many occasions on which we will see you all at our annual conference. Although we hope that future conferences will be more real than virtual, let's hope that a return to normality won't be too far away now, and that we can look forward to a conference next year in some sun-drenched corner of Europe, preferably by the seaside. Many of you will know that between 1987 and 2019, the BEG held an unbroken series of 33 annual conferences in 22 European countries. That series of highly successful conferences was a remarkable achievement, which says a great deal about the vigor, enthusiasm, about the expertise and the high professional standards of the group. In 2020, preparations for the annual conference to be held in Granada were well advanced when, unfortunately, the coming of COVID-19 forced the committee to cancel it. Similarly, this year, the group has been forced to hold its annual conference online. But Philip Moser and the committee are to be congratulated on organizing what promises to be a fascinating program today. We're all very grateful to the speakers for the time and effort involved in writing and delivering your presentations. No easy task, I appreciate, when you have such an expert audience. And we're also very grateful to those chairing today's sessions. And a particular thank you, if I may, to AlixPartners, who once again have sponsored this year's conference. We're very grateful to you for your continuing sponsorship and support. The fact that we're holding an online conference, the only way practicable, means that we will miss out this year on the social side of the conference and the pleasure of being in each other's company. But it does at least have the advantage that it's more accessible to members, as is evidenced by the large attendance and wider participation. It's a great pleasure to see you all here. This is the first time we've met as a group since the end of the Brexit transition period. Brexit, which has dominated BEG conferences in recent years, is now with us. It seems to me that it's a particularly valuable time to be holding this conference. I have no doubt that the need for a specialist bar with expertise in European Union law and the need for the BEG as the Bar Association for Specialist Barristers in this field remain undiminished in the new post-Brexit age. And I say this for a number of reasons. First, as we all know, the field of application of what is now EU law has expanded massively over the years as the EU has developed and acquired new fields of competence. That body of law became more and more integrated into the domestic legal systems of the member states. As a result, the scale of the changes effected in our domestic law and the resulting changes in legal thinking have been immense. The essential requirements of legal certainty and continuity have meant that post-Brexit, by far the greater part of EU law has been transposed into our domestic law. Clearly, there will be a need for practitioners who know and understand these rules, and that need is likely to continue for many years because the transposed body of law is so huge that its amendment is likely to be the work of a generation. Moreover, these are not just rules which now fall to be applied in a purely domestic context. These are rules derived from a legal system with its own unique features, and the effective application of these rules within the context of our domestic systems will therefore call not just for the simple knowledge of the rules, but also, and this is far more demanding in my view, an understanding as to how they worked within the EU legal system. Secondly, you will play an influential role in developing that body of law in the very different context of a post-withdrawal United Kingdom, where the Court of Justice in Luxembourg will no longer be available to supplement or meet inadequacies in what was originally EU legislation, and where the original purposes of such legislation may no longer apply. In future, the nature of your practices may be different, but your skills and your learning will be needed as much as ever. Thirdly, the arrangements for the withdrawal of the United Kingdom from the European Union are inevitably complex. A substantial part of today's programme is devoted to these arrangements. Disengagement with the European Union after so many years, reversing the integration which has occurred in such depth in so many different fields, will bring many challenges. And here, once again, it is to the expert practitioners in the field of EU law that we will look as these new arrangements settle into place. Fourthly and finally, the United Kingdom is now outside the EU, one of the great economic trading groups of nations, but it remains, geographically at least, on its doorstep and with strong continuing trading links with the EU. Those in the United Kingdom who trade with EU member states will continue to need expert advice on EU law in the years ahead, as will those in other states outside the EU. There is no better place to obtain such advice than from the Bar of England and Wales, which has established itself as a source of expertise in EU law, unparalleled either within or outside the European Union. This is a great national resource. And if proof of this is needed, it's only necessary to refer to the attitude of the judges in the EU courts in Luxembourg, who have time and again expressed their admiration for the standards and achievements of the members of the Bar of England and Wales who have appeared before them. So it seems to me that we stand at a major turning point in the history of our legal system, and we will depend on your expertise as specialist EU practitioners to see us through the years to come. I think we are in very safe hands. I must stop now. There's a full programme ahead. thank you all for joining us today. It's a great pleasure to see you all. You're all very welcome, and I hope you will find the conference valuable and enjoyable. Thank you, Philip.
Thank you, David. This brings us on to our keynote speaker this morning, Christopher Vajda QC. Christopher, as you all know, was the last judge of the United Kingdom and Northern Ireland at the Court of Justice of the European Union from 2012 until the withdrawal of the United Kingdom in 2020. And during that time, amongst other things, he sat on both opinion 215 on the free trade agreement between the EU and Singapore and opinion 117 on the comprehensive economic and trade agreement between the EU and Canada. So he has experience of EU law and free trade agreements. He is now back in practice in London and Luxembourg. So Christopher, if I may hand over to you, please.
Thank you very much, Philip. I would like to begin by thanking the group for being asked to deliver the keynote speech at the conference this year. It is a particular honour and privilege to speak not as a serving judge, but as a former judge amongst the very distinguished judges that are here today, including, of course, our president. My only sadness is that I'm speaking to you via a computer screen. The group, as our president has reminded us, has a long and distinguished history. For me, and I'm sure many of you, a highlight of the many previous annual conferences was the eloquent and erudite speech delivered by its former and now sadly departed president, Sir John Laws, after an excellent dinner at which he would regale us about the ancient and not so ancient civilizations of the particular place where the conference was being held. Most of us have a story about John. Let me share mine. We were working together on a case at the bar when he informed me that he would go to New York for the weekend to meet up with his wife, Sophie, who was studying at university over there. When he arrived at US immigration, the officer asked him in rather formalistic tone whether his weekend trip was business or pleasure. John replied, pleasure. The immigration officer retorted, she must be quite a lady, to which John said, yes, she certainly is. She is my wife. Now, that is enough of the past. We need to look, as our president says, to the future. And this is a good place to do so. After 4 years of uncertainty as to what the legal relationship between the UK and the EU is, we now have the legal texts. At the EU-UK level, we have the withdrawal agreement and also now the trade and cooperation agreement. And at the domestic level, we have the 3 UK acts which implement both the withdrawal agreement and the trade and cooperation agreement. Standing back, we can now see that we have entered a unique new legal relationship with the EU. Unique not just from the UK perspective, but also from the EU as well. Take Northern Ireland as an example. The EU has accepted for the first time that the territory of a third country can be within the customs union and some aspects of the single market. The corollary of this is that the courts of that third country are entrusted with applying and enforcing the provisions of EU law applicable to Northern Ireland, and the reference procedure under Article 267, familiar within the EU, continues to apply both to the courts of Northern Ireland and indeed the UK Supreme Court. For its part, the TCA goes beyond what we might call a standard free trade agreement and introduces a number of innovations, including the provisions on the so-called level playing field. It does sound so much better in English than in French. A huge amount has already been said and written, often in the form of very digestible blogs about these major legal changes. This is a demonstration to which our president alluded of the, not only of the vibrancy of the legal community, something which struck me very much when I was the UK judge in Luxembourg, but also of the huge interest as to how these legal rules will work in practice. I'm going to limit myself this morning to two topics: retained EU case law and the future of EU law outside retained law. In essence, EU retained case law is EU and domestic case law where the judgment was handed down prior to 11 p.m. on the 31st of December 2020. Put simply, it is EU law frozen at that date. In England and Wales, the Court of Appeal is entitled to depart from EU retained law, and in Scotland and Northern Ireland, the equivalent courts, and at the UK level, the UK Supreme Court itself. The test for departing from retained EU case law is the same test as that used by the UK Supreme Court in deciding whether to depart from one of its own previous decisions under the 1966 practice direction, namely whether it appears right to do so. We have already had one case in the English Court of Appeal, TuneIn against Warner Music, a case which involved the interpretation of the Copyright Directive by the Court of Justice, where the Court of Appeal rejected an application to depart from EU retained case law. What, to my mind, is interesting about that case is the judges in the Court of Appeal sought, with a varying degree of precision, to list some of the factors why it was not the sort of case where it was appropriate to depart from Court of Justice case law. To my mind, this is an early indication that the courts of this country will be willing to set out a test, or more possibly guidance, in contrast to the previous approach of the House of Lords and Supreme Court under the 1966 practice direction to eschew any such test or guidance so as to leave them with a largely free hand. And in my view, such guidance from the Supreme Court on departure from EU retained case law is not only inevitable, but also highly desirable, if only to bring some degree of certainty to the task of the Court of Appeal, which is likely to face a number of requests to depart from EU retained case law. Clearly, a litigant whose path to success is blocked by a Court of Justice judgment is likely to request the Court of Appeal to depart from that case law. This is an issue that the Supreme Court has not had to face under what I might call its domestic use of the practice direction, since it is the only court with the power to depart from its previous case law, and perhaps understandably does not wish to fetter its own discretion in future cases. Coming back to TuneIn, it was, and it may still be, a dispute between two private parties where neither party has any incentive to consider what I might call the public interest, although of course that does not preclude either party seeking to enlist what it perceives to the public interest in advancing its own case. Yet in a case as in TuneIn, where one party is seeking to depart from previous case law, there is, as all members of the Court of Appeal recognise, an important issue of legal certainty. If the court accedes to that request, the court will have to decide whether its judgment should be declaratory and hence, in effect, ex tunc. That means the judgment would have retrospective effect to the date on which the power was granted. The alternative would be for the judgment to be ex nunc, that is to say, of prospective effect only. If, in order to reduce legal uncertainty, the court decides its judgment will have prospective effect only, the court will come very close to acting as a legislator. To use the expression coined by Lord Bingham in a different context, this is a polycentric question which Parliament, as the legislator, might be considered to be better equipped than the courts to carry out, in particular in balancing of competing interests. However, it is a task that has been entrusted to the courts, and the courts cannot abdicate their responsibility. The question is therefore, how can the courts put themselves in the best position to discharge this responsibility? Where a party asks the Supreme Court to depart from its previous case law, the relevant practice directions 3 and 4 require a party to say so in its application for permission to appeal or its notice of appeal. The purpose of this is to give advance warning to the court for it to decide whether the appeal should be heard by more than the conventional number of 5 justices. I understand that it's intended to amend those practice directions to make it clear that those provisions deal also with a proposal to depart from EU retained case law. Now, while this is welcome, in my view, the Supreme Court should go further than simply requiring a party to notify the court of a requested departure from EU retained case law. The fact that such a notification is felt necessary to alert the court as to whether it should sit in a formation of 5 indicates the particular importance of the case. For reasons that I will elaborate on, I am of the view that the court should notify the 4 nations within the United Kingdom and also publicise such a requested departure on its website as soon as possible after the appeal has been lodged. There are 2 points I wish to make. The first is that the UK Supreme Court is a United Kingdom court. Indeed, it is the only United Kingdom court. And in my view, it is important to give practical effect to that by ensuring that all the 4 nations that make up the UK are given notice of an appeal where one of the parties is inviting the Supreme Court to depart from EU retained case law, which one must remember is law that applies across the UK, and so is in effect UK law as opposed to, say, just English law. I hope I will be forgiven for saying that as those of us who are English lawyers, we may lose sight of the fact that other nations of the United Kingdom may have different views on public policy or whether a particular line of EU case law should be retained or dispensed with. During my time at the bar, I had the privilege of being instructed by the Welsh Government on issues relating to the implementation of EU agricultural and environmental directives. It is a matter of public record that the Welsh Government did not always see eye to eye with Whitehall as to how to implement and apply EU directives in Wales. Let me give you a hypothetical example of what might happen in the future. An English farmer asks the Supreme Court to depart from EU retained case law on, say, environmental standards. If the farmer were successful, such a judgment could affect farming practices in Wales. It seems to me, therefore, that the Welsh Government and Welsh interests should be notified of this in advance of the hearing by the Supreme Court, so to enable them, if they wish, to intervene in a case. Such a notification would demonstrate to Wales and Welsh interests that the Supreme Court is truly a United Kingdom court and not simply an English or London-centric one. As those of you familiar with the Court of Justice procedures will know, the court operates a similar notification system for cases lodged before it. The statute of the court requires it to notify all the member states and EU institutions of all incoming cases. In the case of a reference, the notification takes the form of translation of the order of reference into the national languages of all member states. On the basis of that notification, a member state can decide to intervene, which entitles it to see the written pleadings and make its own written and oral submissions. This is a feature greatly valued by the member states, and it is unthinkable that the member states would consent to its removal. As a judge, I also found it useful and sometimes almost essential. I recall a reference from member state A, where I was the reporting judge. All parties from that member state and the Commission proceeded on this assumption that the starting point was some previous ECJ case law. However, member state B intervened to argue forcefully why that line of case law was either not applicable or wrongly decided and should not be followed. As it turned out, member state B was correct. But for that intervention, the error might have been perpetuated. Secondly, so far as other interested parties are concerned, other than the 4 nations, publication on a court's website would assist them in finding out about a pending case of importance to them. Again, their contribution might prove to be of assistance to the court in deciding this quasi-legislative and polycentric question and result in a judgment which has been seen to take account of all relevant views. In the recent judgment of the Supreme Court in Halliburton and Chubb, the Supreme Court had to consider the duty of disclosure of an arbitrator, an issue of huge importance to the United Kingdom and indeed international arbitration community. There, the court had the benefit of a number of interventions from non-governmental associations who had different perspectives on the right approach to take. Those interventions were reflected in, if I may say so, the very impressive judgment of the court. The arbitration community is well organised and the grapevine works well. One cannot, however, assume that all potentially interested parties would be so well informed in all types of cases where the issue of EU retained case law may arise. I have focused on cases where a party is seeking to depart from EU retained case law, but logically there is no reason for such a notification system to be confined to a possible departure from EU retained case law. It would, in my view, be apt to cover any case where a party signalled its intention to request a departure from previous House of Lords or Supreme Court authority under the 1966 practice direction, and insofar as it is not already covered by Rule 40 of the Supreme Court rules to declarations of incompatibility under the Human Rights Act of 1998. The Supreme Court has already an excellent website, and there would, I think, be no practical difficulty in providing the necessary public notification on its website once the appeal notice has been lodged. Although forthcoming cases are put on the website, this is only a few weeks before the hearing, which may not leave much of any time to make an application to intervene. A similar notification system should, in my view, be introduced mutatis mutandis for other appellate courts, such as the Court of Appeal. These changes would help to bring such appellate courts closer to the citizens within the United Kingdom and should ensure that the courts have before them relevant arguments for all the affected parties in the way that would occur if these polycentric issues were to be ventilated in Parliament. We live in an era of greater transparency and participation in public life by the ordinary citizen, referred to in previous eras as the man on the Clapham omnibus. For the type of case I have referred to, I do not think that simply putting out a daily cause list with the name of the parties remains appropriate. In this respect, the Competition Appeal Tribunal is a role model. It has an excellent website which publishes a summary of all its incoming cases. Let me now move on from the topic of EU retained case law and consider the future relationship, to use the term of the 2020 Act, between the common law and non-EU retained case law. That is to say, EU laws it may develop in the years to come. Common law, as we all know, is the law developed by judges. As Lord Gough famously observed in the Kleinwort-Benson case, the common law is a living system of law reacting to new events and new ideas, so capable of providing the citizens of this country with a system of practical justice relevant to the times in which they live. We pride ourselves in this country on the development of the common law over the centuries. Happily, the common law has also travelled well, particularly to the distant parts of the Commonwealth. But the success of the common law is, if I can mix metaphors, a two-way street. That is to say, judgments of Commonwealth countries are cited in English courts when our judges are looking as to how the common law should develop in this country, in the absence of English precedent, or indeed where Commonwealth courts have declined to follow an English case. And all this is done without any statutory underpinning. In the past, and certainly before the UK acceded to what is today the EU in 1973, it would indeed be rare for English courts to cite judgments from countries or bodies that did not belong to what we might term the old Commonwealth. There were many reasons for this. First, the absence of a common legal tradition and the fact that continental legal systems were civil law systems often based on the Napoleonic Code, which was alien to the legal systems within the United Kingdom. in many continental countries, the idea that judges would create and develop the law as in the common law jurisdiction was anathema. Secondly, the judgments were generally not available in English, and even if they were translated, the drafting style was very different to the kind of judgment that we were used to. Judgments often consisted of a series of laconic assertions. Allied to that, there was no regular contact between judges in the UK and mainland Europe. And finally, in the case of the Court of Justice, there was little overlap in the subject matter of cases. In those pre-1973 days, the diet of the court in Luxembourg consisted of mainly coal and steel cases, customs, some free movement, and competition. The position, as our president has indicated today, post-Brexit, is very different. Let me start with the legal systems of some individual states on the European continent. The highest German courts have English language websites where English language summaries of their judgments appear. The German Constitutional Court has produced judgments in many important areas such as privacy, which are of great relevance to the issues that we face in this country as well. I have recently had occasion to read the judgment of the German Federal Court of Justice, the highest German civil court, in the Siswell and Heyer case, a judgment delivered in November of last year. It concerned the question of when the conduct of a holder of a standard essential patent who seeks to injunct an infringer in a so-called FRAND dispute constitutes an abuse of a dominant position contrary to Article 102 of the treaty. The judgment runs to 138 paragraphs and is written in a style that is understandable to UK lawyers. The judgment cites not only the leading Court of Justice case of Hawaii and ZTE, but also with approval, the High Court judgment and that of the UK Supreme Court in Unwired Planet and Hawaii. I should add that in Unwired Planet, the Supreme Court itself carried out an exhaustive analysis of foreign cases, including cases from Germany, in dealing with the submission that English courts were out of step with foreign courts on their approach to FRAND licensing. Moving to France, judgment writing there is changing too. While in my judicial capacity, I struggled on occasions with references made to the court by the Conseil d'État and the Cour de Cassation, there is now a greater recognition within the senior French judiciary that judgment should become less laconic and give fuller reasons. Now, where does the court in Luxembourg fit into all this? I would suggest quite well. It is a court with which the UK legal profession has become very familiar, not just in terms of subject matter of the cases, but also the style of judgments, and indeed the more personal and discursive style of opinions that bear a closer resemblance to judgments in the common law world. While the somewhat formulaic style of judgments may not be to everyone's taste, the judgments themselves have become more, if I may say so, common law in feel than the judgments in pre-accession days. The judgments recognise the importance of precedent and citing, possibly in my view, oversighting previous case law, and applying the technique of distinguishing previous case law. So their technique of judgment writing is readily understandable. The judgments and opinions are available in English and will continue to be so. And the court's judgments will deal with a large number of subject areas that will continue to be of the greatest relevance to the UK legal system. Let me just take one example, competition law. In 2020, last year, the Supreme Court decided the case of Peninsula Securities and Dunnes Stores. This case concerned the lawfulness of a restrictive covenant accepted by a developer of a shopping centre in a lease that he granted to Dunnes, a retailer, over part of the centre. Dunnes was what is known in the trade as the anchor tenant. The lease was then assigned by the developer to connected party Peninsula. Peninsula subsequently sought to argue that the restrictive covenant in the lease was in restraint of trade. Peninsula, however, faced a major difficulty in that the House of Lords had decided in 1968 in Esso Petroleum and Harper's that the restraint of trade doctrine was not engaged when a party had not given up a pre-existing freedom. This was the case for Peninsula, which had taken the assignment of the lease with the covenant, but it was not the case for the original developer. Nonetheless, Peninsula won in the Court of Appeal of Northern Ireland on the basis that there was no public policy reason, and as the court pointed out, that was the basis on which the doctrine of restraint of trade is based, for the doctrine not to apply at the point of the assignment of the lease. So what was the Supreme Court to do? It began by reviewing the academic and Commonwealth judicial reaction to Esso. It concluded that in the half century since Esso, there'd be no reasoned defense to the pre-existing freedom test. The question then arose, what to do next? The court decided that the so-called trading society test proposed by Lord Wilberforce, who was in the minority in Esso, was preferable. This test is whether the restriction have, and I quote, become part of the accepted machinery of the type of transaction which is generally found acceptable and necessary. So instead of being regarded as restrictive, they're accepted as part of the structure of a trading society. Lord Wilson, giving the judgment of the Supreme Court, frankly conceded that the trading society test is conceptually unattractive. It is not rooted in principle. And if I may respectfully say so, it seems to contain an element of circularity. That is to say, when something is part of the accepted machinery of the type of transaction, it is lawful. But by what token does one decide whether something is part of that accepted machinery? And indeed, as Lord Wilson observed, at the time that Esso was decided, almost all UK petrol filling stations had become subject to restrictive covenants, yet Lord Wilberforce felt able to conclude on balance and without any evidence that the practice had not become acceptable and necessary as part of the structure of a trading society. Nevertheless, the Supreme Court decided that Lord Wilberforce's somewhat elastic test was preferable to the rather inflexible pre-existing freedom test, and therefore used the practice direction to depart from Esso. Now, what, may you ask, has any of this to do with EU law? The answer is that EU law has a developed competition law regime which recently dealt with an analogous issue. Article 101 of the treaty prohibits all agreements which have more than a de minimis anti-competitive effect unless they can be justified under special gateways. Parliament in this country decided in 1998 to bring the EU system of competition law into our domestic law through the Competition Act 1998. And Article 101 now equates, or has equated for nearly 20 years, to the Chapter 1 of prohibition in the 1998 Act. In 2011, the UK Parliament decided no longer to exclude what are known as land agreements, which include leases and assignments from Chapter 1 agreements. In November 2015, the court in Luxembourg decided the case of Maxima Latvia, a case quite similar. There, the anchor tenant was given a right of veto over leases being granted to other traders in the same shopping centre. In competitive terms, or competition terms, the effect of this clause was similar to that of the restrictive covenant imposed on Peninsula. The court applied its familiar case law when a clause in agreement has the effect of restricting competition within the meaning of Article 101 to restrictive covenants in shopping centres. It indicated the National Court needed to look at matters such as barriers to entry, the degree of retail concentration, and the counterfactual. This approach provides more flexibility than the pre-existing freedom test, and if I may say so, is rooted in principle. But I'm not saying that the approach of the court in Maxima Latvia necessarily provided the answer in Peninsula or was preferable to the trading society test. What I am saying is that it would have been good to have had Maxima Latvia put on the table, if I can put it like that, before the Supreme Court, so it had a fuller picture in deciding what was a better test than the pre-existing freedom test. By way of illustration, over 25 years ago, in the landmark case of Woolwich and the Inland Revenue Commissioners, Lord Gough was able to draw inter alia on the case law of the court in Luxembourg on the recovery of unlawfully paid charges as support for his conclusion that the time had come for English law to recognise in an area untrammelled by EU law that taxes paid by a citizen to a public authority pursuant to an ultra vires demand was in principle recoverable. Now, going back another 25 years or so before Lord Gough's speech in Woolwich, Lord Diplock delivered in 1971 the first Upjohn lecture entitled The Common Market and the Common Law. The position, of course, was the reverse of what it is today. The UK was about to accede to the EEC, as it was called. Today it has left. But as one would expect, the lecture delivered by Lord Diplock that evening in Gray's Inn still repays reading today. I hope you will forgive me if I conclude by quoting a little bit about what he says on the common law. Insularity is in more senses than one an attribute of the common law in the geographical context of Europe. As anyone who worked intimately with European lawyers will know, many of our legal concepts reveal or perhaps conceal subtle differences from those of the civil law systems. But in the wider context of the world, this insular system of common law has shown remarkable powers of survival wherever it has been introduced. There is, however, one respect in which English lawyers have in the past earned the reproach of insularity. 40 years ago, when I was called to the bar, the study of comparative law was wholly neglected in this country. We have made little progress since then. It has become the practice in appellate courts, at any rate, to refer to decisions of courts of other countries in which comparable legal problems have been dealt with. But up to date, citation has been mainly limited to decisions of courts in other countries whose law is based on the common law system. This will not be the first time that English common lawyers have faced this kind of problem. In the 18th century, the law merchant, much of which owed its origin to civil law, was incorporated into the English common law by the genius of a Scot, Lord Mansfield. Independently of our accession to the Treaty of Rome, the inevitable trend today is towards uniformity of the substantive law on matters affecting trade and intercourse which crosses national boundaries. There are few fields of human activity which in the shrinking world of speedish carriage and communication do not do that. Already there is a proliferation of international institutions in which this country is a participant, devoted to the task of achieving uniformity of national laws. This will be a two-way process. In the course of my lifetime in law, I've been fortunate enough to work with European lawyers to believe that the common law has much to gain from closer contact with and understanding of the concept of the civil law. I believe too, just as strongly, that it has much to give. In my view, the words of Lord Diplock are as relevant in 2021 as in 1971. The common law thrives on adoption, assimilation, and cross-fertilization, including, I would suggest, from the flowers and faunas of the European legal system. In this rich ecosystem, the Bar European Group has an important role to perform. And as our president has said, I am confident that it will rise to the challenge for the benefit not just of its own members, but for the wider legal community in the United Kingdom, including the judges. Let us remember that Sir John Laws was a great advocate of the common law. He would indeed be proud to see the group go forward in this way. Thank you.
Thank you very much, Christopher, for that talk. And I saw David taking notes about your suggestions for the Supreme Court, which I look forward to being put into practice shortly. And we come to our next speaker, who is Clare Brodie. Clare is General Counsel for the Trade Remedies Investigations Directorate, which is due to become our Trade Remedies Authority very soon now that the Trade Act 2021 has passed through Parliament. Claire's been working with the Department for International Trade to set up this new organisation since 2018, and they launched their first trade remedy investigation in 2020. Before taking on this role, Clare worked in various different parts of government, including the Brexit Department, the Cabinet Office, and the Competition Commission. Before joining that, Clare worked in competition law in a city law firm and the US. So Clare, if I may hand over to you, and you have indicated that you will be taking questions if people want to put questions in the Q&A.
Thank you very much, Philip. I'm just going to try and share my screen with some slides, if that works. No, that doesn't seem to be working today. It worked on the test. Just let me try one more thing, otherwise I will make a start. No, very well. So
shall I see? I think I have a copy of your slides. Should I see whether I can bring them up and maybe share them on your behalf? You just have to tell me when to change.
Thank you.
Right, here we are. There we go. Can you see the slide?
Great, that's perfect. So thank you. Thank you very much for inviting me to speak today about the Trade Remedies Authority and this new work we're doing on trade remedies. If I can have the next slide. So I just wanted to think about why are trade remedies important in this trading landscape after EU exit? Trade remedies are a key feature of the WTO trading rules, and they protect UK industry from unfair trading practices by foreign exporters. In particular, there are three types of measure involved. Anti-dumping, which is where cheap imports are being dumped in the UK and harming UK industry. Countervailing measures, where foreign subsidies on imports to the UK are harming UK industry. And safeguards, where a sudden and unforeseen surge in imports causes serious injury to UK industry. Safeguards are global measures that apply against all imports coming to the UK, whereas dumping and countervailing measures apply to exporters from particular countries. Anti-dumping measures make up the vast majority of trade remedy cases, and safeguards are very rare. But there are increasingly more countervailing or subsidy cases, and we do at the moment have a very high profile steel safeguards case, which we are looking at. This steel safeguards case followed the introduction of steel safeguard measures by the EU in 2018, which in turn followed the US imposing their steel protection measures on national security grounds. In fact, this week, we have just published our provisional findings in the UK steel safeguards case, which involve looking at 19 different types or product categories of steel and recommending that measures, safeguard measures, continue for 3 years for 10 of those categories of product. So these trade remedy measures are a really important part of protecting UK industry and are an important part of the UK's trade policy and trade defence after EU exit. To put it in context, the Department for International Trade has rolled over or transitioned 39 EU trade remedy measures at the start of 2021. We at the Trade Remedies Authority are now looking at transitioning these through transition reviews to decide whether to vary, revoke, or maintain the measures. To give you some idea, of these 39 transitioned measures, 26 are anti-dumping, 12 are 12 are countervailing or subsidies measures. One of them is a safeguards measure. And quite interesting to note that 27 out of the 39 involve China. They concern a really wide range of industry sectors, including steel, aluminium, chemicals. We have ammonium nitrate, biodiesel, bicycles, road wheels, and tyres. So potentially there's a lot of measures that we're transitioning across to continue to protect UK industry. The remedies in these cases involve additional duties on imports and can be really significant. For example, we have also just published our provisional findings in our first anti-dumping case involving welded tubes and steel pipes, which recommends maintaining duties of up to 90% on imports from China. And I know from speaking to other trade remedy practitioners that sometimes the duties can go up as high as 200%. So trade remedies are a really important part of ensuring fair trading conditions, and they have developed as a key feature of the WTO trading rules. They derive from the General Agreement on Trade and Tariffs and the underlying anti-dumping agreement, the Subsidies and Countervailing Measures Agreement, and the Safeguard Agreement, and they've been heavily used by WTO members. Since 1995, the US has imposed over 500 anti-dumping measures and 168 countervailing measures. The EU has imposed 335 anti-dumping measures and 45 countervailing measures. They've also featured very heavily in WTO disputes, and indeed the majority of WTO disputes concern trade remedies. If I could have the next slide. So turning to the Trade Remedies Authority and our work on trade remedies, as mentioned, we are currently focusing on transition reviews of rolled over EU measures. So the Department for International Trade did a call for evidence to identify which EU trade remedy measures were relevant to the UK, and having rolled over 38 plus the safeguards case, we must now examine these to decide whether to maintain them for the UK. We will look at whether there is dumping or subsidy, and in particular the likelihood of dumping or subsidy and injury reoccurring if the measures are removed. This actually involves quite a complex investigation process. We send out questionnaires to the parties, which is UK industry on the one side and foreign exporters on the other side. We examine and verify data on dumping, subsidy and injury, for example, looking at import and export prices, costs and sales data. We prepare a statement of essential facts or provisional findings. We consult with the parties, and we then make a recommendation to the Secretary of State for International Trade, who takes the final decision, applying a public interest test. The investigations tend to take between 12 and 18 months and normally involve travelling overseas to carry out investigation and verification work. We have around 120 staff, and we work in teams that include lawyers, accountants, economists, and investigators. We also have to apply a UK economic interest test in our cases, and this is an additional requirement over and above the WTO rules. It's a WTO plus requirement that the government has decided to introduce, and it looks particularly at the economic significance of the affected industries and consumers, the impact the trade remedy measures would have on them and on particular geographic regions or groups, and the likely consequences the measures would have on the broader competitive environment in the UK. We can only recommend maintaining or varying trade remedy measures if this economic interest test is met. We are an independent and arm's length body, we will be once established as the Trade Remedies Authority, but we only make recommendations, and the Secretary of State will take the final decision in all of our cases, applying a broader public interest test. However, she can only veto or reject our recommendations and cannot substitute her own view. Parties can then apply for reconsideration before making an appeal. An appeal lies to the upper tribunal tax chamber. States can also launch WTO disputes against the UK in respect of our findings. And this is something that Department for International Trade will really handle on a state-to-state basis. We will also be looking at new trade remedy measures. In addition to these transition reviews, we'll look at new measures when UK industry make an application to us. The WTO rules are really quite stringent on when a new investigation can be launched and require us to establish that there is sufficient evidence of dumping and subsidy before we can start a new case. So we've set up a dedicated pre-application office to help industry understand the requirements and make their applications. In setting up, we had a lot of helpful training from EU colleagues and particularly experts who'd worked as part of the European Commission on trade remedies. And they noted that sometimes it can take up to 12 months to prepare the application process before it's launched. Under our legislation, under the Trade Act 2021, we also have a role in providing other advice and assistance to the Secretary of State on trade. For example, in the context of negotiating trade agreements, we may be involved in the trade remedy chapters of the trade agreement. And also, obviously, WTO disputes on trade remedies, we may be involved in those too. So we have quite a lot to do. And as trade law and trade remedies have not been done in the UK for over 40 years, and transition reviews are very unique, there are a lot of really interesting issues to grapple with. If I can have the next slide. So thinking a bit about what the future holds for us. I think in terms of the EU, it's going to be very interesting once we start to conclude the transition reviews. We may expect trade remedy measures to start to actually develop between the EU and UK. Obviously, the rolled over measures really apply against third countries, the rest of the world. So it'd be really interesting to start to see trade remedies being applied actually between the EU and UK. There are also some quite interesting provisions in the EU Trade and Cooperation Agreement on subsidies that complement and supplement the trade remedy rules. Trade remedies do feature in the EU Trade and Cooperation Agreement, but don't really add very much over and above the WTO requirements. However, there are these additional provisions on subsidies, which are very interesting. For example, the EU and UK can apply new measures to subsidies, which have a significant negative effect on trade and investment between the EU and UK. In doing so, they have to take into account any trade remedy measures that also apply, and be really interesting to see how all of this works together. At the international level, there is also a lot of discussion about foreign subsidies and dealing with the problems caused by different types of foreign investment and, for example, transnational subsidies. The EU has been developing its proposals in this area over the last year. And a couple of weeks ago, it published a draft regulation to examine foreign subsidies that harm the level playing field and the EU single market, going beyond situations that involve trade remedies and countervailing measures. Among trade remedy authorities, there is quite a lot of focus on how to deal with non-market economies and market distortions. Dumping, in particular, involves looking at and comparing the price the goods are being sold in the UK with the price that they're being sold in the foreign or home market, for example, China, to see if they're being dumped in the UK. So how do you deal with a foreign market that has distortions or operates under non-market trading conditions? How do you ensure a fair comparison between the export price to the UK and the price the goods are being sold in the home market? Authorities are increasingly identifying non-market economies or distorted markets, and then referring to other comparator markets or constructing prices using economic data. And this is quite a difficult area. The suspension of the appellate body in the WTO is also an interesting and challenging factor at the moment, and means that trade remedy disputes are frequently being appealed into the void, leaving issues unresolved and creating some uncertainty. There are alternative dispute methods developing, and also the UK has its own domestic appeals system, as I mentioned, a statutory appeal to the upper tribunal tax chamber. So we can perhaps expect greater use of these. So it is a very interesting time to be involved in this developing field of law in the UK. And it is very exciting to be involved in this at the Trade Remedies Authority. We are really looking forward to our commencement as an authority, now that the Trade Act has passed through Parliament, and now that we're starting to do live investigations. Finally, on this slide, I've included a snapshot there of gov.uk, where we've been developing a lot of guidance about what we do. That is our sort of opening page there on gov.uk. We have guidance that we've produced about the trade remedy investigations process. We also have guidance from the Department of International Trade, and under the Trade Act, we're required to have regard to all of that guidance. And we also have an online digital service called the Trade Remedies Service. We're really trying to be a very digital organisation, and so that the exporters and foreign parties that we deal with can provide all of their information to us through that portal. So do take a look if you'd like to find out more. Thank you.
Thank you very much, Claire. Now, we do have time for some questions for Claire. If someone has any, there's a question and answer function at the bottom of your screen. If there are no questions for Claire, then I propose that we might move to our break early. But I'll give you a few moments. Or indeed, if any of the other panelists, David or Christopher, have a question for Claire. No, I think you've answered everyone's points on the authority exhaustively. So thank you all for attending the first morning session. I'm going to spend the break transferring attendees to panelists for the second session. And can I ask you, it's probably easiest if you simply remain online if you're an attendee. And can I ask everyone please to be back in good time for our 12 o'clock session, which will be chaired by Lord Justice Lewis. It's on the mechanics of the new TCA, the withdrawal agreement and retained law, and it will feature Tom de la Mare QC and James Segan QC of Blackstone Chambers and Jack Williams of Monckton Chambers. So it only remains for me to thank all our speakers for this morning's session. And I look forward to seeing or hearing everyone at 12. Recording. And welcome back, everyone, and including the attendees. This session is going to be chaired by Lord Justice Lewis. Clive, for the one or two people who don't know, was a fellow in Lord's Selwyn College and a lecturer in law at Cambridge University, and is a former chairman of the Administrative Law Bar Association, our sister SBA. He was presiding judge in Wales until 2019 and has been a Lord Justice of Appeal from 2020. So Clive, I will hand over to you.
Thank you, Philip. Well, good afternoon, everyone. It's lovely to see you, virtually speaking. Welcome to the next session, which concerns the mechanics of the Trade and Cooperation Agreement, the withdrawal agreement between the United Kingdom and the European Union, and the operation of retained EU law in the UK. We have three speakers, each of whom will speak for about 15 minutes. and that will leave us about 10 to 15 minutes for questions. And if anyone wishes to ask a question or make a comment, they can use the question and answer box at the bottom of the screen, and fingers crossed I'll be able to use it as well and relay your question to the waiting world. Our first speaker is James Segan QC, who's a barrister at Blackstone Chambers with a broad practice in regulatory and commercial law, and he's written and spoken regularly on legal issues concerning the United Kingdom's departure from the European Union. And he's going to give an overview of the legislative framework governing relations with the EU and EU law going forward. So James, if you'd like to enlighten us or at least speak to us.
I shall attempt to do so. Thanks, Clive. In January this year, the Divisional Court, in a case called Polakowski, emphasised the heightened importance after Brexit of approaching any legal question involving rights and obligations said to be derived from EU law in the first instance through the lens of domestic law. That's paragraph 18 of Polakowski. Now, I begin by emphasising that because over the decades before Brexit, we had all become used to arguing cases under EU law, largely without reference to the statutory mechanism by which that law came to be enforceable. Its full effect was taken as read. The European Communities Act 1972 was, of course, the subject of lots of discussion at the time of the Miller number 1 case, in particular about its status as a so-called conduit pipe. Well, in the last 3 years, that conduit pipe has gradually been replaced by what is now an elaborate sprinkler system dousing us with law from all sides in the same substantive policy areas. So where we once had EU law, we now have retained EU law, we have statutory modifications to retained EU law, we have rights and obligations under the Withdrawal Agreement, and we have rights and obligations under the Trade and Cooperation Agreement. And in many cases, they overlap. And what we're going to do in this session is very briefly to outline the framework of questions that now falls to be considered, which is my job. And then Tom and Jack are going to consider in greater depth some of the more difficult issues that arise from it, particularly in relation to retained EU law. But obviously the practical question in any case governed previously by EU law now is how do I work out what the law governing my claim actually is? And I think there are 2 broad stages to that analysis. The first is what I'm going to call the temporal stage of the analysis. And the second is what I'll call the source of law stage. Now, to explain that and taking those in turn, the first question, the temporal question, is what period of time do the facts in my case relate to? And the dividing lines are, of course, the 31st of January 2020, the day of exit from the EU, and the 31st of December 2020, the end of the transition period. Now, Tom is going to cover this point, this temporal point, so I won't tread on his toes, but the short question is, if the events in issue relate entirely to a period prior to 31st of January 2020, does one need to get into the complexities of retained EU law as opposed to EU law proper at all? As I say, Tom's going to discuss some of that. Likewise, if your claim relates to events during the implementation period, then again, arguably the same or similar question arises in view of the fact that the European Communities Act 1972 was saved for the period of the implementation period by Section 1A of the Withdrawal Act 2018. And indeed, the Withdrawal Agreement itself says in Article 4 that union law is supposed to have the exact same effect in the UK during the implementation period as it did beforehand. As I say, Tom's going to get into more detail into that, but that's the first question. And the purpose of asking that first question is, of course, to identify what are the relevant sources of law to be applied. The task then at the second stage is to apply in order and according to their respective hierarchy or status in the hierarchy, the sources of law that I mentioned earlier. And the easiest way to illustrate this stage of the analysis in operation is for us to assume that we're concerned here with events which occurred entirely, shall we say, in March this year. So entirely in the period in which the UK has fully left the EU. Now, to work out what the law applicable to your claim in that situation actually is, there are now at least 4 key questions which you need to ask yourself to get to the answer. The first is, what is the retained EU law which was transposed into UK law as at 11 p.m. on the 31st of December 2020? The second question is, have any of the Brexit SIs changed or repealed that retained EU law? The third question is, does the withdrawal agreement have anything to say on the topic? And the fourth question is, does the trade and cooperation agreement have anything to say on the topic? And let me just briefly take those 4 stages in turn, because they in a sense outline the framework that applies. So first stage, identifying the retained EU law. This is the stage that in principle ought to be, and probably is, the easiest of the 4. As we all know, the Withdrawal Act 2018 has the effect in very broad terms of preserving, as has already been mentioned this morning, preserving in aspic the entire body of EU law as it stood at 11 p.m. on the 31st of December 2020, and constituting it as a new body of UK law, retained EU law. It applies to EU legislation, decisions, CJEU cases, and the such like. EU law textbooks, accurate as at 31st of December 2020, are only going to increase in value, so retain them on your shelves. But even at this first stage of the analysis, of course, there are exceptions and complexities, and let me just give 3 examples. First of all, as Christopher has already mentioned this morning, the Supreme Court and Court of Appeal can depart from retained EU case law subject to certain conditions. And Christopher's mentioned the tune-in case in which the application for departure from CJEU case law was unsuccessful. As I understand it, and this touches on what Tom's going to come to, the application was consciously restricted to facts arising after the 31st of December 2020. I just park that there for now. Now, whether and how far that power under Section 6 is exercisable in other cases where the facts arose earlier is what Tom's going to cover. That's the first exception. The second exception relates to rights under directives which are not of a kind recognised as directly effective by a court prior to the 31st of December 2020. Those rights are not carried over. And there's a very difficult and potentially very important issue as to exactly what is meant by of a kind recognised in that provision and how broad or narrow it is. An important topic, and I know Jack is going to cover that. To give some other examples of exceptions to the preserving in aspic, for instance, special time limits have been placed on Frankovich actions and in actions based on the general principles. And it seems to me, looking at the transitional provisions, that there is a pretty good argument that those time limits do apply even where the facts arose before Brexit. But I'm sure there's scope for argument one way or another in that regard. And there are, of course, all the many exceptions we know in relation to the Charter of Fundamental Rights, how the general principles operate and the such like. But the core of the first stage is ascertaining a historical fact. What was the state of the EU acquis as at 11 p.m. on the 31st of December? One then turns to the second question, identifying any relevant Brexit SI. Well, retained EU law is defined in the Act, the 2018 Act, Section 6, subsection 7, as including the body of rights preserved by Sections 2, 3, 4, and 6 of that Act, as that body is added to or otherwise modified by or under this Act, or by other domestic law from time to time. So retained EU law is not just what law there was at 11 p.m. It's also the body as it is modified by the Act or under domestic law. And we know that the Withdrawal Act 2018 included some very wide-ranging powers indeed to modify retained EU law if it was perceived to be deficient. There has been an avalanche of these Brexit SIs over the course of 2020 and 2021. I searched this morning and it seems there are now 1,038 such statutory instruments. They have made some dramatic changes to retained EU law. Most of the important treaty articles, which it was suggested in the explanatory notes to the 2018 Act would actually be continued as retained EU law, have been repealed, such as the competition provisions in Articles 101 and 102. There are lots of more subtle but equally important changes given the sheer range of policy areas from nuclear safeguards to sanctions to plant breeding. It's impossible to summarize, but one example was discussed this morning in relation to jurisdiction, where we have a statutory instrument for obvious reasons repealing Brussels recast and Lugano, putting nothing in their place. So we're back to the common law. And as Philip mentioned this morning, it seems that the Lugano application is not doing particularly well, to put it mildly. And of course, at this second stage of the analysis, one has to consider whether there's a virus challenge to the statutory instruments. Putting 1,038 statutory instruments on the statute book in a period of about 14 months is a pretty ambitious legislative exercise. There are strict limits in Section 8 of the Act as to the circumstances in which the powers are available, and in the haste to get those instruments on the statute book, it may be, to put things mildly, that those limits have not always been respected. But that's the second stage, look at the SIs. The third stage is the withdrawal agreement. Now, Section 7A of the Withdrawal Act 2018 provides that all rights, powers, liabilities, obligations and restrictions under the withdrawal agreement are to be given effect in domestic law. And it also provides explicitly that every enactment, so that's the whole of the rest of the statute law of the UK, is to be read as being subject to those rights, powers and liabilities. So it's an equivalent of Section 2 of the European Communities Act 1972, but as regards the provisions of the withdrawal agreement. Now, of course, that agreement dealt primarily with the period up to the 31st of December 2020, but its effects by no means end at that point. And the most prominent example is Part 2 of the withdrawal agreement about citizens' rights. That gives a whole swathe of rights to EU citizens present in the UK, which are available explicitly for their whole lifetimes under Article 39, and references to the CJEU are possible in that regard to the end of 2028. So whether any particular right exists, you determine in accordance with the EU test under Article 4. Then the fourth stage is the Trade and Cooperation Agreement. One has to ask what effect the TCA has. That is dealt with by the European Union Future Relationship Act 2020, EUFRA. I'm sure many of us will have looked at it. It is a very lean statute indeed, it's fair to say. It has in parts 1 and 2 some specific provisions about security and trade, but they're pretty narrow. One then gets to the all-important part 3, which is entitled General Implementation. And one sees in that part essentially a single statutory provision in Section 29 of EUFRA, which is made to do the enormous job of giving effect to the whole of the TCA in domestic law. It's about 70 words long, but they are potentially some of the most important words which are on the statute book today. They provide, in a very similar way as has been provided in respect of the withdrawal agreement, that existing domestic law has effect on and after the relevant day with such modifications as are required for the purposes of implementing the Trade and Cooperation Agreement, so far as the agreement is not otherwise so implemented, and so far as necessary for complying with the international obligations of the UK. Now, Lord Justice Green in Lipton and City Flyer described that as a sweeping up provision. I would respectfully agree, but would observe that it leaves the task of deploying the broom entirely in the hands of litigants and the courts. Parliament has left us with a lot of sweeping to do, it's fair to say. And I say that because, of course, the TCA is an enormous beast. I had only just got used to dealing with a rather odd numbering of the original provision, Comprov this or that, when they renumbered it with proper article numbers. It's now 993 pages long, the main body of the treaty. It has mini frameworks for all kinds of different policy areas. Telecoms, there's a kind of précis of the CRF. In some areas, there's minimal provision like financial services. In others, it seeks to summarize the existing EU framework. As Claire mentioned earlier, there are some detailed rules on subsidy control. Sometimes the rules are subtly but importantly different from the EU framework, which is preserved by the 2018 Act. And there are whole new sections of obligations in there. For instance, there is a Title 10 on good regulatory practices, which commits public bodies on both sides of the channel to various forms of good regulatory practice. Unclear exactly how it's supposed to operate, but it appears that where major regulatory measures are proposed, the rules on consultations and impact assessments in the treaty will apply over and above the common law, if and insofar as they give additional protection, because of course section 29 takes precedence. And it's section 29 which does the legwork of incorporating all of those very extensive provisions. It immediately raises the question of whether it is supposed to create individual rights. Now, Article 5 of the Trade and Cooperation Agreement says that nothing in the agreement itself shall be construed as conferring rights or imposing obligations on persons other than those created by the parties under international law. But section 29, which of course is not the agreement, it's a freestanding piece of domestic law, positively requires all domestic laws to be adjusted so as to give effect to the agreement. And of course, many of those laws do give rights to individuals. So there's a very interesting question there as to how far section 29 requires you to go in implementing the TCA. Now that is, I appreciate, a long road to travel to get to an answer to the basic question, what is the law that governs my set of facts? But those are the questions that one has to ask. And once one has traveled that road, one gets the answer to that basic question. And in order to address in greater detail some of the challenges that arise along the way, I hand over at that point to Tom, with Clive, I assume, coming in.
Well, thank you very much, James. That actually was a very clear exposition of quite a complicated structure, and I've taken detailed notes lest they ever be relevant. Our next speaker is Tom de la Mare QC, whom everybody at Beg will know. Tom's a barrister at Blackstone as well. He practices in a wide range of areas, including public law, what was EU law, and now it's offspring EU retained law. And Tom is going to tell us what EU retained law is and what it's not. So over to you, Tom.
Thank you, Clive. There are few more frequent flyers in the charge sheet against the CJEU than its case law on the delayed boarding regulations. Indeed, if you were going to make such a charge sheet as a critic of the court, the popular items would be item 1, every social security case up to Danu, item 2, every citizenship case from Chen, item 3, Sturgeon and all the DBR case law, item 4, VNUC and the Motor Insurance Bureau case law, and then it would be a debate thereafter. Now, what's interesting about those items on the charge sheet is that most of them have been prioritised for repeal. Indeed, social security law and citizenship law, save as preserved by the Withdrawal Agreement, has all been repealed by the Immigration and Social Security Coordination Act. There is no retained EU law whatsoever in those spaces. The cases of Lipton and City Flyer and Verano and Air Canada, I think, are going to be the latest twist in the history of the delayed boarding regulation, because they're a very powerful optic to see the problems that arise in relation to the question of what is retained EU law. Now, at the heart of Lipton, there was, I suggest, a fundamentally unmeritorious substantive point, which was whether or not a captain's illness was an exceptional circumstance under the regulation. It had long been established that mechanical failures or matters of that kind weren't exceptional circumstances, and it's very difficult to see how a captain falling ill, as will happen from time to time, was fundamentally different. It's something airlines should plan for through rostering and, if necessary, insurance. But remarkably, the airline won in the argument that this was an exceptional circumstance in relation to a flight from 2018. They won before the Deputy District Judge in 2019, and they won before the judge on appeal in 2020. All of that then came before the Court of Appeal on a second appeal, and that came before the court after the magic date of the 1st of January 2021, in other words, after IP completion day. So we're dealing with a case of a captain being taken ill and a flight being cancelled in January 2018, well before even the transitional period being started. And of course, before the courts below, there was never any argument at all about retained EU law, because all they were interested in was the law as it existed at that stage. Court of Appeal's judgment really splits into two parts. There's the judgment or the speech of Lord Justice Coulston, which deals in a characteristically meticulous way with the distillation of principles from the pretty difficult case law about what is exceptional circumstances, before arriving at I think the powerful conclusion that, of course, this wasn't an exceptional circumstance, and therefore the basis for overturning the judgments below. But what's of note in that analysis, and I think it's part and parcel of the problem with this case, is the very things that weren't argued and weren't contested. There was no suggestion, so far as I could see, at any point in this case, that the CJEU case law on the delayed boarding regulation should be departed from. It was a dispute about what principles could be obtained from that case law and how they should be applied, not a dispute about departure from a clear principle. Nor was there any suggestion in that case that the relevant part of the DBR, Article 5.3, had gone through any material substantive change when it became part of retained EU law. So there had been a Section 8 EU exit SI, but as is often the way, as is predominantly the way in my experience, having read far too many of these things, substantive law is left largely unchanged. What happens with the Section 8 statutory instruments is changes of procedure are made. They're to get rid of the old machinery of EU institutions, the old machinery of cooperation, of notice, of mutual recognition. And so that's why you see something like Rome I and Rome II, substantive law remaining in place, because they're all about substantive law, whereas goodbye recast regulation, because it's all about procedure. What then causes the metaphorical pricking up of the ears about this case? What's the excitement for you nerds like me, and I hope like you? Well, it's the judgment of Lord Justice Green. It is a beautiful textbook exposition of the workings of EUA. It takes you through exactly the type of analysis James has just taken you through. It explains how you have to look for the original law, how you overlay the retained EU law with the relevant SIs, how that may then trigger an examination of whether or not to depart from case law under Section 6.3 of EUA if you're the Court of Appeal or the Supreme Court, and then finally an analysis of the potential application of Section 29 of the of UFRA and the TCA. And that's because, and this is really perhaps the pivot in this case, Lord Justice Green observed at 53 as follows: submissions and argument advanced to us during the appeal proceeded very much as it would have done in 2019 when the UK was a member of the EU. However, the hearing took place in February 2021 when the transitional agreement had expired. At this point in time, a new set of legal arrangements are in place which govern the relationship of the UK to EU law. The court cannot therefore assume that the old ways of looking at EU-derived law still hold good. We must apply the new approach. There is much that is familiar and there are significant differences. Now, undoubtedly, this is a beautiful castle of legal analysis, and undoubtedly it's unimpeachable for anyone who has a case, the facts of which arise after the 1st of January 2021. It's undoubtedly correct in that circumstance. But there are two things that flow beyond that from Lord Justice Green's analysis. The first is the clear assumption that this whole new regime of retained EU law applies to the past, to 2018. It's not just the future that is governed by retained EU law, it's the flights and the illnesses back in 2018. And that rather depends on the rather suspect premise, I think, that because something now is a question of retained EU law, it must be treated as always having been a question of retained EU law, and that retained EU law has effectively expanded, notwithstanding the substantive changes in substantive scope. It's expanded to embrace the past. So there's an implied premise of retrospectivity or retroactive effect in all of this. And the second thing that flows from it is that once retained EU law applies to the past, it follows that the powers of the court in section 6.3 to depart from CJEU case law also apply to the past. And that's because when you look at section 6.3, it's a peculiar, section 6 in particular, is a peculiar mixture of procedure and substance. Section 6.1, which abolishes the right of a reference to CJEU, is a procedural change. Section 6.2, which is the change of the precedential effects for the future, may be either a procedural or substantive change, but it's only future operating. It's not applying in relation to the past. But section 6.3 and 6.4 are conditioned only to apply where there's a question of retained EU law arising. It's only in the case of a retained EU law problem that the power to depart from CJEU case law applies. And it is obviously substantive in its operation. And that rather begs the question then, do the powers to depart from retained EU case law apply to disputes that themselves are in the past? Now, as for the retrospectivity of this analysis, any doubt on that has been removed by a recent decision of His Honour Mr. Justice Webb, Great Webb QC, sitting as a Deputy High Court Judge, from Monday. It's another DBR case called Verano. Once again, the facts are all comfortably pre-transition period, let alone IB completion date. It's about a flight from 2016. The relevant article was Article 7, the provision that entitled you to differing tiers of compensation depending on the levels of delay. The debate was about whether or not a second leg of a flight, which had started in the EU and then gone to Toronto, and then from Toronto to Austin, whether the second Austin to Toronto leg was outside the EU regulation scope by dint of the fact that it was all abroad. In the course of the argument, well, the judge heard the arguments, and then before judgment was reached, Lipton was handed down, and he invited a clarification from the parties as to whether or not they said the substantive law to be applied was the DBR pre-IP completion day or the DBR post-IP completion day, as Lord Justice Green contemplated in Lipton. The claimant said it was the latter. Air Canada argued no, it was the original DBR that was to be applied, and they invoked Section 16 of the Interpretation Act. The judge concluded he was bound by Lipton to conclude that what was necessarily applicable to the past was the amended DBR. He concluded that it didn't make any difference on the analysis of the article in question and the relevant question of scope. But instead of awarding the €600 required by the old DBR regulation, he awarded the new modified sum of £520. But it's fair to say to the judge that he was entirely alive to the risks and perils of retroactivity in Lipton. Indeed, he gave the following example. Compensation under the DBR is dependent upon you being a community carrier. The new DBR regulations apply only to UK carriers. And he posited the situation that if it was the amended DBR to be applied, if someone had been claiming in relation to a community carrier before the regulations were amended, they would lose, on the basis of the Lipton analysis, their cause of action, because they would no longer have such cause of action under the amended DBR. Now, if you want a good illustration, therefore, of how far-reaching this retroactivity argument is, that cause of action point is a very good example. But let me give you another one. Suppose the sum of 600 euros wasn't roughly equivocated across to £520. Suppose it was reduced to £10 or 5p. What would happen to your entitlement? You had a clear vested entitlement to 600 euros back in 2016, and yet it's being said by dint of a change in the law some 5 years later, your settled expectations have been changed. That is, with respect, absurd. It's contrary to the basic common law principle that substantive legal change, unless clearly authorised by Parliament, does not occur retroactively. There are any number of House of Lords and Supreme Court decisions to that effect as a matter of common law, even before you get into the operation of Article 1, Protocol 1, Pressos Naviera and the case law on settled expectations, even before you get into the Human Rights Act and the Charter of Fundamental Rights. And that basic principle has been codified in Section 16 of the Interpretation Act that says the repeal of a statute doesn't change the law for the past, and any vested rights or privileges will continue, notwithstanding the repeal of that enactment. That leads to the basic problem with Lipton. Section 16 and this argument about the past simply wasn't argued. It wasn't cited. The court didn't have any argument before it on that topic. And more fundamentally, there was no argument about what the purpose and effect and scope of EUA was. And this is really, in my submission, the basic point. The purpose of EUA is to provide for legal continuity. It is to domesticate what was EU law and to make it, with the necessary changes, domestic law with effect from the 1st of January 2021. There is no intention in the Act, properly construed, to change the law from the past. Indeed, were there any intention to do that, it would be a fundamental breach of the United Kingdom's international obligations. There's a very good and easy illustration of that. Article 127.1 of the Withdrawal Agreement provides the EU law shall continue with full effect during the transition period. That article is given effect by the provisions of EUA, Section 7A in particular, and yet any retroactive change in the case law, any retroactive change in the entitlement, from whether it's from 600 euros to 520 pounds, is an abnegation of that principle. And with respect, exactly the same analysis applies in relation to the periods covered by the European treaties for the periods of time in which we were contracting parties. What happens, therefore, is that effectively Section 2 of the European Communities Act and everything that flowed from it continues to supply substantive law up until the beginning of the transition period. And thereafter, it's Section 1A of the Withdrawal Act, EUA, which has since been repealed, that then supplies the law in the intervening transitional period. You can do a simple test. Can you sue for a breach of Article 101 in a period, let's say, a breach occurring in 2016? Can you sue even though Article 101 has been repealed with effect from the 1st of January 2021? The answer is yes, you can, because you have an accrued right. And that accrued right hasn't been repealed. Indeed, it's recognised in the transitional provisions in the competition SI. And that being so, effectively what you're asserting is that the law as given effect by the European Communities Act in 2016 continues to apply for that purpose. Those vested rights succeed. So I fear all of this is going to have to be substantively argued at some stage before the ripple effects in cases like Verano get too unpleasant. Clive will be interested to know that this point is live in the appeal from his judgment in the case of Hughes and the Pension Protection Fund, because if the main appeal against the application of the principles fails, the PPF is going to argue that the case law applied therein, Hampshire, etc., should be departed from. using the powers under section 6.3 of the Act as amended by the precedent regulation. And that will lead to an argument on precisely the terrain here, because of course the facts in Hughes all preceded the IP completion date. One final point then is how all of this feeds into the powers to depart from CJEU case law. And I listened very carefully to Christopher Vajda's excellent talk on this. One feature I think that will become particularly important in the case law is just how the impact of any change to a CJEU case law will impact upon vested rights. And I think a very powerful argument against the use of the effective legislative powers conferred on the courts, it will be a situation, an anomalous situation, where you have acquired and accrued rights that have to be respected up until the 31st of December, and yet a change is made thereafter. It's for reasons like that that in the Spratilla case, the government is attempting ambitious argument to suggest that effectively quashing orders should only work until the 31st of December, at which point effectively an order that's quashed as incompatible with EU law should revive on the 1st of January 2021. I think there's going to be a lot more of that, and a lot more of argument about in re spectrum plus and prospective overruling prompted by these powers of departure. So all extremely problematic, it seems to me, in the light of acquired rights. Just a taste of one of the many deep and intractable problems these provisions are going to produce. God help the Court of Appeal in a case involving a litigant in person and an old delayed boarding regulation case.
Well, thank you very much, Tom. That, as usual, is typically thought-provoking. It's rather like Donald Rumsfeld. James dealt with the known unknowns. You've just created a whole series of unknown unknowns, problems that I hadn't even thought of, actually, about applying it to facts that occurred entirely before implementation day. Our third speaker is Jack Williams, who's a barrister at Monckton Chambers, also active in EU law. He contributes frequently to a Monckton blog, Euro Relations Law, and he very thoughtfully sent me an article he thought would be helpful called Retained EU Law, a Guide for the Perplexed, clearly thinking that would be right up my street. So Jack is going to talk about directives as retained EU law, so I'll hand over to Jack.
Thank you for that very kind introduction. I hope that my slides can now be seen on the screen. Listening to James and Tom, I'm somewhat reminded of a scene from Only Fools and Horses. I recall Del Boy, Rodney and Trigger sitting in a cafe, and Trigger is proudly wearing a medal, which he says he's been awarded for services to the community. And Rodney asks, what service to the community has he performed? And Trigger replies, it's on account of saving the council money. And he says very proudly, I've had the same broom for the last 20 years. Now, at this moment, Del Boy obviously pipes up and says, well, if you've had the same broom for the last 20 years, have you actually swept any roads with it? And Trigger replies, well, we have an old saying handed down by generations of road sweepers, look after your broom. And that's exactly what I've done. I've maintained it for the last 20 years. This old broom has had 17 new heads and 14 new handles in its time, you know. Now, Del Boy, of course, comes in with the obvious punchline, how the hell can it be the same broom then? And so I'm sat here thinking rather the same in relation to retained EU law. It's the same, but oh, very different. I'm going to discuss one fiddly difference with retained EU law, and that's the position of directives. The question is this: if a directive provision has not been implemented properly or at all, and so there's no domestic legislation pursuant to Section 2 of the EU Withdrawal Act, or none capable of being interpreted compliantly, in those circumstances, can one still rely directly on the directive provision? Now, the answer to that question is in Section 4 of the Act. Section 4.1 essentially says, to reduce it substantially, that any rights, etc., which used to flow down the Section 2.1 of the ECA conduit pipe continue to do so and are retained. Section 4.2, however, has a carve out for that for provisions of directives which are not of a kind recognised by any court in a case decided before implementation completion date. That's the 31st of December last year. So it says directive provisions which are not of that kind are not retained EU law. Now, I personally don't like double negatives, so let's put that point the other way around. Directive provisions which are of a kind recognised by a court do form part of retained EU law pursuant to section 4.1. But the real question, as James has highlighted, is what exactly does the of a kind wording mean? To my mind, it introduces ambiguity and the potential for great argument, because I think it can have one of two meanings. Firstly, it could mean that only a particular directive provision which falls within a category of provisions which have themselves specifically and expressly been held by a court prior to the end of the transition period to be directly effective would be retained. So we can call that the narrow or the empirical interpretation. Essentially, you look for a past case and see whether that particular directive provision has been held to be directly effective. Now, that appears to be the common reading of the section. However, I think there's a second broader reading and interpretation. It could instead mean any directive provision of a kind which would fulfill the well-known conditions for direct effect, sufficiently clear, precise, and intended to confer rights on individuals, etc. And they would be retained whether that particular directive provision has or has not been held to be directly effective prior to the end of the transition period. So we can call that the broad or the conceptual interpretation. Essentially, you look at the provision of the directive, is it of a kind which would satisfy the direct effect tests? Now, at this juncture, it's interesting to look at what the explanatory notes themselves say to the Act. I think nowhere is the ambiguity or inconsistency clearer. The first sentence of the explanatory notes says that of a kind is intended to ensure that rights are retained if they are of a similar kind to those so recognised. Now, if you stopped there, you'd think that the drafter had in mind the second broader interpretation I had. You assess the directive provision rather than just searching for a past case. But the passage continues. So, a non sequitur, if I've ever seen one, rights arising under a particular directive that have been recognised by court could be relied upon. And then later on in the passage, as underlined, rights arising from any directly effective provisions of directives that have not been recognised will not be converted. So it appears that the drafter really has in mind the first, narrower, empirical interpretation. But I think there are three arguments for the broader interpretation of a kind, which, just to repeat, is that a directive provision would be retained where it is of the sort recognised by courts before IP completion date, i.e. where it would meet the direct effect criteria. I think the first argument for the broader interpretation is that the narrow interpretation arguably reads out the phrase of a kind entirely. The effect of section 4.2b would, I think, be the same as the narrower interpretation contends for, with or without the phrase remaining. But words tend to mean something. As Lord Reid in Black-Clawson said, we often say that we're looking for the intention of Parliament, but that is not quite accurate. We are instead seeking the meaning of the words which Parliament used. We are seeking not what Parliament meant, but the true meaning of what they said. And personally, I think the words of a kind are intended to mean something. The second argument for a broader interpretation is that where a provision of a directive so obviously has always met the requirements of the direct effect test, it's unlikely to ever been litigated. So that means there will not be a finding for a directive provision by a court prior to the end of the transition period. Now, there's no sustainable rationale, in my view, for that provision not being retained, such that it can be relied upon directly, if not properly implemented in domestic law already. The lack of a case is essentially one of misfortune rather than good reason. The third reason for a broader interpretation is that if the narrower interpretation were correct, then directives which the UK has transposed inadequately will be incapable of giving rise to directly effective rights unless there is a precise case on point. That would be so even though had the UK properly fulfilled its EU obligations, the right would have been implemented. So the UK would essentially be benefiting from its own unlawful act. This also seems inconsistent with the Act's overall intention, as Tom has mentioned, of retention and keeping the status quo. Now, I have a beg exclusive for you, a case that I'm not aware has been blogged or tweeted about at all, which is something of an oddity in the modern world. That case is one called G&G, and both the Supreme Court judgment of this year and the Court of Appeal judgment of last year are relevant. Now, two caveats before I begin. First, after hearing Tom, I am going to make an assumption that the courts were correct to analyse the fact pattern through the prism of retained EU law without any comment. It's a Saturday and I'm too junior to be making any reference to pairing Curiam judgments from both the Court of Appeal and the Supreme Court. So let's assume that the prism of retained EU law is accurate. My second caveat is that the point in question about the meaning of a kind was based again on a council concession and appears not to have been fully argued at all. You will find no express consideration in the judgments of what of a kind means. My reading of the judgments is instead based on necessary implication after a somewhat painful and forensic tracking through of the cited cases. Now, I don't have time, I think, in the time available to get into the background facts, but I've put references on the slide, and the key points are as follows. Essentially, the courts held that the Nationality, Immigration and Asylum Act of 2002 did not properly implement the provisions in the Procedures Directive or the Qualification Directive. And then the courts then found that the relevant provisions of those directives were directly effective and that remained as retained EU law and thus could be relied upon directly. Now, the real question is, how did they get to that conclusion? What does it tell us about the of a kind meaning? Is it a broad or a narrow interpretation? As I say, the judgments are silent on that particular topic, but if you track through the different judgments and what they rely upon, there may well be an answer implicitly. In relation to Article 7 of the Procedures Directive, the Supreme Court found, relying on the Court of Appeal, that it was a right arising from a directive which has been recognised by our courts. So pausing there for a moment, this tends to support the narrower interpretation of a kind. You look for a specific case where that specific directive provision was relied upon. For Article 21 of the Procedures Directive, however, there's no explicit reasoning. So I went back to look at the Court of Appeal judgment to look for the past cases that it cited. It again makes remarks, again based on a council concession, which suggests that it was relying on a narrow reading of Article 4, Section 4.2b, It said, and I quote, rights conferred by a directive will be retained if they've either been transposed or in any event recognised, either as part of a ratio of a case or obiter by the domestic courts prior to IPC date. So that's a narrower interpretation. Now, in relation to Article 21 of the Qualifications Directive, the court cites a case of AD. But when you read AD, the court there only expressly found that Articles 4, 13 and 18 of that directive were directly effective. It does not say that Article 21 was directly effective. It does, however, mention that Article 21 creates a duty on the member states to respect the principle in Article 21, so perhaps it is weak authority. And for Article 7 of the Procedures Directive, the Court of Appeal cites the case of F&M. That case makes only passing reference to Article 7, but it doesn't consider specifically whether it's directly effective or not. So again, perhaps it's weak authority. So where does that leave us? It seems that the courts in G&G were tracking through and looking for directive provisions which had been recognised by a court, the narrower provision. But it seems to me that the weight of authority actually cited in those cases is relatively weak. The point was not argued explicitly. It was done by a council concession. And the courts in neither the Court of Appeal judgment or the Supreme Court look at the wording of a kind specifically and consider the points that I've raised. But it does seem that the weight of authority is the first narrower interpretation has taken hold. But I hope, and I think based on the circumstances I've discussed, the point remains open for full argument. There is, I think, only one benefit of this ambiguity, us, the lawyers. So to end with a quotation from Delroy again, perhaps next year we'll all be millionaires. or perhaps we're the only fools. Thank you.
Well, thank you very much, Jack. Fools and horses I can grapple with. That's, again, extremely interesting and a problem that I hadn't really thought about. We've got time for some questions and answers. I've got some questions too. Robert Palmer's got a question for Tom. Was the judge in Verano correct to conclude that he was bound by Lipton on the issue of temporal effect? The objection is that Lord Justice Green's analysis with obiter appears powerful. So Tom, what do you think?
I think it was obiter, and I also think it was per incuriam insofar as it's setting out principles that apply to pre-IP completion day. And there's quite a large number of material provisions that haven't been considered that are relevant to answering that question. So I think the judge would have been fully entitled to depart on both grounds.
Right, gosh, yes, so that's very interesting. Any of the other two of you disagree with that view of the judgment in Verano, and in particular whether Nick Green's analysis was obiter, or are you solid on that? And which one of you is going to tell Nick?
Since he's the judge hearing the appeal, and I know he's on this call, since he's the judge hearing the appeal in PPF, he may well have to be deciding that point for himself fairly shortly.
Yeah. There's a question from Martin Howe, particularly for Jack Williams. Does Jack think that the Mare leasing doctrine, consistent interpretation of EU law and domestic law, survives after departure from the European Union in relation to the interpretation of United Kingdom legislation, which was not passed to amend or transpose a directive? So Mare leasing has always been used to achieve a consistent interpretation of domestic and EU law. And Martin is asking Jack in particular whether that Mare leasing doctrine applies when the directive was not specifically implemented by the UK law in question. So Jack, any thoughts on that?
Yeah, it's the not that's thrown me. The answer where it's been passed pursuant to a directive to transpose, I think is a clear yes. There are a number of different routes to get to that. You can either go through the Section 6 route in that there is a retained case, i.e. Mare leasing, or there's wording in Section 2, for example, which talks about at the time of the original law, which would have been at the time of the EU. So I think the duty of consistent interpretation applies where it's the domestic law was passed to amend or transpose the directive. Where it's not passed or amended to transpose a directive, I'm not sure that it would apply. I'm not sure it would ever have applied. You've got the duty of supremacy still retained in Section 5, which will flow through. But I can't see the route, the analytical route, being as clear, unless Tom and James will correct me otherwise.
Jack, all I'd add is that I think this whole temporal point actually supports the wide reading of Section 42B. And the reason I think that is as follows. Suppose you have a directives provision that's, let's say, according to the standard test of the CJEU, obviously directly effective, but it's never been considered for one reason or another. Let's say by reference to the relevant novelty of the directive or something like that. It's an obviously directly effective provision. The directive's only been in force for a year or so before we leave. That question, if I'm right about whether that's a question of retained EU law, if that arose in litigation and it wasn't a question of retained EU law, it was just a question of EU law, it would have to be answered by reference to EU principles. You'd apply the direct effect test, just like the CJEU you wouldn't have the option to refer, the national court decides for itself. Now, if that's the approach that arises in relation to what I call old EU law, then it would be anomalous in the extreme if after the 1st of January 2021, you then suddenly go back to a much narrower approach, just as happenstance as to whether or not the particular provision has been litigated or not, and if it has, and only if it has, is it directly effective. So I think once you start thinking about the temporal angle, it feeds into a necessarily wider interpretation of Section 42B, which makes total sense to me. I just don't understand what policy lies behind a narrow reading of 42B. It's just accident whether or not provisions are litigated or not. It's not principled.
And I think, sorry, just on that question, I as just reading the statute and looking at the context, I would absolutely agree with that. The issue is actually, I think, is that second passage of the explanatory note that Jack draws attention to, because it does basically suggest that the narrower reading is the right one. But so there'll be an issue as to the extent to which that is admissible and what weight it should be given and the such like. But on the Mare leasing question, I essentially agree with Jack. I mean, the broadest one gets in terms of the sort of fallback doctrine that you can rely on for purposive interpretation is Camin's ballrooms that was applied by the Supreme Court in Risk Management Partners to say that even if you're not within the strict ambit of Mare leasing, you can interpret purposively if you have a directive in the background. But if it's a situation where the relevant legislation was not passed or amended to transpose the directive at all, I'm not sure that even that broad fallback doctrine would apply.
Could I ask Tom a question about Section 6 and the power of the Supreme Court and the Court of Appeal to depart? I hadn't thought about a situation where all the facts had occurred prior to implementation day, and the court was being asked to view that as EU retained law and whether they should be invited to depart from it. Is it going to be possible to use the power under Section 6 to say, as a court, we're not going to depart from it in relation to past events, because that wouldn't be, in inverted commas, fair or in the public interest, but we will depart and give a different meaning to the same provision in the same directive for future events, because that's more consistent with some overall legislative purpose in the UK. So could we have the same provision meaning different things in relation to the past and to the future? Or that
I think we're undoubtedly going to get into that type of argument. I agree with you that it's instinctively unattractive to have the same thing meaning different things depending on the time of the litigation, but there may be contexts in which that argument has sufficient weight. That's why I think we're into in re spectrum plus and the development of the court's very rarely used powers of prospective overruling, and doubtless that is going to be a fertile furrow. But it's also the reason why, as James pointed out, Counsel in Tune-In Radio made the very sensible concession they did. So Tune-In Radio was a case about the meaning of communication to the public, which is a key term in IP infringement. And effectively, what Counsel for Tune-In Radio said is, I accept the EU definition and meaning of communication to the public as established by the case law must apply for all of the infringements Tune-In Radio is alleged to have committed up to the 31st of December. But as from the 1st of January, you are free from that date going forwards to adopt a different meaning of communication to the public, departing from the CJEU's case law. And therefore, so far as it's said that I'm infringing now or have infringed from the 31st onwards, you can apply that different test and we're not infringing. So there's shades of what you're suggesting there by how you formulate your argument. So you do get into that, and I would suggest that that's actually a powerful reason against accepting that argument, because it looks bizarre in circumstances where there's no change in the substantive obligations mediated through the Section 8 EU exit regulations. It does look bizarre that the same thing means completely different things at either side of the magic date. It's a pretty unattractive argument, ultimately.
Okay, now anyone else got any further questions before Philip dashes around delivering sandwiches to everybody on the attendee list? He's got a busy lunch hour ahead. If not, I would thank all the speakers. That's been a really excellent session, both to put a comprehensive framework on how we approach EU retained law and also to identify pitfalls that one hadn't even thought about. It's been a really, really interesting session. So I'd be grateful if we could all sort of metaphorically clap all three speakers and thank them for their contribution today. So Philip, are you about to start the sandwich delivery?
Thank you, Clive. Yes, I'll be right over.
Good. Philip lives 4 doors away.
So thank you, Clive, for chairing it so wonderfully. I'm going to maybe abuse my position as chair by just adding a sort of footnote to that, which is that the CJEU itself of course, has the interesting habit of determining the application, the temporal application of its judgments from time to time. It seems in its discretion. So this one is going to apply from now, this was going to apply from before. So perhaps that's not as peculiar as one might think. But thank you all. And we look forward now to our lunch break. And at 2, we're going to have the next session, Competition Law and the Digital Economy, which is going to be quite an intense session of 4 panelists chaired by Lady Rose JSC. And I hope that we're all going to be back online then. And I'm going to spend the time now moving the panelists into and out of the spotlight. So thank you again, and see you shortly. So the chair of the next panel is going to be Lady Rose. Vivian Rose is the newest recruit to the Supreme Court, as again everyone here knows. You practiced from Monckton Chambers before going to the bench via the unusual route of the Government Legal Service. Vivian was also the president of the Upper Tribunal Tax and Chancery Chamber from 2015 to 2018, went to the Court of Appeal in 2019, and the Supreme Court in April 2021. And I will gratefully hand over to you.
Thanks very much, Philip, and welcome back everybody to the conference. I'm going to introduce all our speakers first, and they will each speak for about 10 minutes. And after hearing from them all, we'll have our question and answer session. But please don't wait until the end of the session to ask your questions. You can ask them at any time by typing them into the Q&A box at the bottom of your screen. And if your question is directed at a particular speaker, then you can say, and at the end, I'll pick up the questions and direct them as appropriate. So our first speaker is Iona McCall of AlixPartners. She's a professional economist with 18 years experience and specializing in competition and regulatory matters. And she has an established reputation both as an advisor and an expert witness, particularly in relation to anti-competitive agreements, abuse of dominance, and private damages claims. I know Iona very well, as she's one of the leading lights of an excellent organisation, Women at Competition Network, which is an international network aimed at increasing the participation of women in conferences and panels like this. And Iona is going to be speaking about theories of harm in the digital economy. Our next speaker will be Anneli Howard QC. Anneli took silk in March 2021 as it is standing counsel to the Civil Aviation Authority. She's active in a number of standalone and follow-on claims, including the Which Qualcomm collective proceedings. And she's recognised by Chambers and Legal 500 for EU international trade, competition, consumer telecoms, and regulatory public law. And Anneli is going to be talking about public enforcement of competition law, both ex post and ex ante. Anneli will then pass the baton to Gaucho Rasmussen. Gaucho has been Ofcom's Director of Enforcement since 2016. And before joining the UK Civil Service in 2012, Gaucho worked in private practice as Tesco Group's competition counsel and also did a spell as a referendaire in the General Court in Luxembourg. And he's going to be talking about sectoral regulation with particular emphasis on the online safety bill, which was published by the government earlier this month. And our final speaker will be Rhodri Thompson QC, speaking on private enforcement remedies. Rhodri is a leading specialist silk in competition and EU law. He's honorary treasurer of the UK Association of European Law, and he chaired the Bar Council EU Law Committee from 2018 to 2020, and the Joint Working Party on Competition Law from 2013 to 2018. He has also acted for Unlocked in their claim against Google and has appeared in many of the leading cases in the CAT, in particular pending applications for opt-out collective proceedings arising from EU trucks. So I invite Iona to get us going. Thank you.
Thank you, Vivian. Before I start, I just really quickly want to make a quick disclaimer. I or colleagues of mine are involved in a number of the cases we're going to be discussing today, so I won't be offering too much of an economics opinion on the cases. Rather, I'm going to focus on more of the factual theories of harms underpin them. So just to make that clear. So to start with, I think it would help just to explain what we mean by the digital economy, or more specifically digital platforms. So in general terms, digital platforms act as intermediaries between consumers and businesses, and they can take a variety of forms and business models. But they have a number of common features, and in particular, they tend to be multi-sided markets. They connect two or more groups. So for example, Amazon connects buyers and sellers, YouTube connects consumers with content producers and advertisers. And that creates sort of what we call indirect network effects. So there's a relationship between the two sides of the market. So the fact that you have more users makes your platform more attractive to, say, your sellers, and potentially vice versa. Digital platforms also have strong direct network effects. So instead of this interaction between both the two sides, or the multiple sides, there's a relationship just between the users or participants on one side of the market. So effectively, the more users there are, the more attractive the platform is to an individual user. So if you think about something like Facebook, the more of your friends or family that are on it, the more value it has to you to be on it. Digital platforms also have significant economies of scale and scope. And the scale point in particular, I mean, a number of these business models, the cost of servicing an additional user can be close to zero, if not zero. So, we're talking very significant economies of scale. And finally, they have access to large volumes of data. And that can create a feedback loop as well. So the more users you have, the more data you have, and the more data you have, the better able you are to refine your offering to make it more attractive to users. So then you attract more users, and then you have more data, etc. It's a sort of self-fulfilling prophecy in a sense. Now, none of these features or characteristics are new in and of themselves. There are a number of different markets that demonstrate some of these, at least. What's distinct about digital platforms is that they combine all of them. And what that means is you have network effects, which tend to result in a market tipping towards a single dominant provider, combined with economies of scale and scope and access to data, which allow platforms to then consolidate their position in a market, or even an associated market, depending on the nature of the platform. And on top of that is an additional layer, because these kind of dynamics are reinforced by then consumer biases. So in particular in these markets, sort of a status quo or default bias and prominence biases are quite significant. And I'll refer back to those in a moment when I dip into the cases. So all these factors combine to mean that we end up with markets where you have are likely to result in a sort of a winning firm, let's say, that has a large degree of market power. Now, I just want to make that really clear that none of that is driven by anything specific that these companies do. It is purely a function of these features of the market. So it's inevitable in some sense. There is, however, a risk that they can use that power, and they can use it to further protect or strengthen their position in that market or in associated markets. And we've seen recent cases actually that have highlighted a number of sort of forms that these strategies can take, and the types of theories of harm that we're seeing in with digital platforms and digital markets. I mean, none of these are new, and I'm going to talk through a few cases briefly. None of these are new, but what's interesting is actually that the features of these markets mean that certain types of conduct may result in slightly different impacts, or have a more detrimental impact potentially on competition. So or equally so, they could actually be less detrimental, but anyway. So taking one of the early commission investigations into Google shopping, so Google was found to be leveraging its dominant position in the general search market to benefit its shopping comparison service, and it's doing this by favouring it in the search results. So it was giving it more prominence. So the idea was that this self-preferencing foreclosed the competing shopping comparison sites. And I mentioned the word prominence because, again, this really relates to the ability to exploit consumer biases and the fact that consumers tend to respond more directly to material that is more prominently displayed on the site. Google Android case then, a few years later, we saw both tying and exclusivity agreements being used to strengthen Google's position. And the tying case was actually somewhat reminiscent of the old Microsoft case, where Google was found to be to have leveraged its dominance in the App Store market by tying the installation of Google Search and Google Chrome to the installation of the Play Store. They were also, on the exclusivity agreement side, they were also found to be making payments to device makers and the mobile network operators to not install other search engines on their devices. And again, we come back to the behavioural, the behavioural biases here, because the default bias is what made this a valuable exercise. Consumers tend to rely on the default settings on their devices. Now, obviously, we see tying and exclusivity agreements in other markets, but in digital markets where you have network effects and economies of scale, the tying and exclusivity contracts actually can allow the platform to prevent potential rivals from achieving the scale that they need in order to be able to compete in the market. Amazon as well has also found itself at the centre of a few investigations. So there was the old ebook case, which focused on the most favoured nation, use of most favoured nation clauses, and the commission found that Amazon was forcing publishers to inform them of any terms, more favourable terms that they'd offered to Amazon's competitors, and in some instances requiring them to match it. And we've seen this again in the UK with the CMA looking at the price comparison websites and the use of wide most favoured nation clauses. More recently, Amazon, the commission's looked at Amazon in terms of marketplace and the buy box. So these are two slightly different cases where the marketplace of theory of harm, if you like, well, to be honest, it's not entirely clear currently exactly what the commission's focusing on because it's a very early stage, but it relates to the use of, it relates to the role of Amazon as a platform and a downstream seller. So it competes with the sellers on its platform by selling its own products downstream as well as operating the platform. And obviously as the platform, it has access to information and data on these sellers' activities, which and the investigation is sort of really thinking about whether that's given Amazon unfair advantage in that downstream market selling. The buy box case is slightly different because it actually relates more to Amazon trying to leverage its dominant position in one market into another, and this is in relation to its logistics services. So the Amazon's dominance in e-commerce is being used in theory to leverage dominance or leverage its position in the logistics services and what they call e-commerce fulfillment. And basically it comes down to the fact that Amazon offers these services, and the allegation is that they are giving the sellers that use their own logistics services preferential treatment. So greater visibility on the site, and more importantly, it increases the likelihood that these companies are then selected, the sellers are selected for the buy box. And the buy box is effectively Amazon's sort of recommendation. So if you sort of use your sort of do an automatic buy, it will automatically buy from the buy box, the buy box recommendation. So it has a huge implications for revenue for these sellers. Very quickly, because I'm running out of time, but another sort of feature of these markets is of digital platforms is the zero pricing, and actually the theories of harm around exploitative abuses and thinking about zero in the context of zero pricing, it has raised some interesting questions about non-monetary dimensions of this, and in particular the value of data. And the German Facebook case has been an example of where these issues have really come out. Apart from the investigations by the regulators, of which I haven't given you a comprehensive overview, just to be clear, there is also private litigation. There's private actions that have been filed that have highlighted other issues. So in the US in particular, we've got the Epic Apple case, which centers on the allegation by Epic that Apple's exclusive use of the App Store and the iOS ecosystem means that Apple's been able to charge excessive rates of commission and actually exclude competing app stores and alternative payment systems. The case is ongoing and it's actually in court at the moment. In the meantime, though, in the UK, a consumer standalone claim has actually been brought on the back of that. So there are a number of different cases. They've sort of illustrated the potential for digital platforms to use their market power to reinforce their position and undermine competitors in their core markets. But as well as it's also demonstrated the scope to leverage across markets and to foreclose competition-related markets. And it's also raising questions about, you know, the different types of exploitative conduct that's maybe slightly different from traditional forms we've seen. Before I hand over to Anneli, I want to just finish very quickly with a thought about what a lot of this means in terms of regulation, because obviously the nature of these markets and the features of them has raised the question as to whether ex-ante regulation is actually also needed to go alongside competition law. And Anneli is going to discuss that in detail. But just to sort of highlight a couple of points from an economist perspective, you know, traditionally ex-ante regulation is focused on industries where the body was it was a national monopoly. And actually these have tended to be natural monopolies, you know, very significant sort of capital investment, a lot of it infrastructure that means that only one company really can offer these services, at least in a specific region or area. Whereas what we're talking about here is very different. We're talking about very dynamic, innovative markets where actually there is the scope for competition, and in particular through disruptive innovation. And the fact that, you know, this idea that companies try to leapfrog each other and actually compete for the market, which results in, you know, new products and services, which is obviously great for consumers in the long run. So it's kind of just a word of caution, I guess, that with any sort of regulation, considering that balance of the risk of chilling investment and undermining actually the potential for dynamic competition in the market is incredibly important. And with that, I will hand over to Anneli. Thank you. Anneli, I think you're on mute.
I'll try once more. Sorry, that screen share didn't work, but we will try again. There we go. Hopefully that's working. So I'm going to talk about the public enforcement of the digital economy and its increasingly recognised importance of online platforms, which now represent about 150 billion for the UK economy. And in this next slide, if it will let me move it. Are you able to, sorry, this was working earlier. It's not going to let me move it. One sec. There we go. Shows the kind of recent events that are really delivering ahead of steam on the public regulatory side. Now, Iona's gone through many of the key milestone cases that have been happening at both at the EU and the UK level. But there has been a recognition that perhaps antitrust isn't the best way to be dealing with these cases. And you only have to look at the timeline of some of these cases to realise how long these investigations are taking. So the Commission started its investigation into Google Shopping and Google AdSense in 2010. It issued its decisions and fines totaling over £8 billion in 2017. And those cases are still awaiting judgment from the General Court now, some 11 years later. And in the meantime, there's some recognition that the markets aren't working effectively, that there has been reduced growth and innovation. The CMA estimates that the platforms have generated higher profits, approximately 1.7 billion, which will have been passed on to consumers in the form of higher prices. They're worried about lower consumer choice, with the consumer being left with a take it or leave it binary choice, and reduce intermediary services. So 80% of advertising apparently is spent on Google and Facebook, but not other outlets. And they're also worried about the reduced quality of service, recording that 50 to 60 adverts an hour appear on Facebook rather than the kind of content that consumers actually might want to see. So in the light of those concerns, both the CMA and the EU Commission have stepped up. In 2018, the government commissioned the Furman Review, which was published in March of 2019 with a series of recommendations. The CMA has also published its own market study in July of last year, where it's recognised these concerns and then put forward recommendations of how to address them. And in December 2021, the CMA has established its own new regulatory framework, and at the same time the EU Commission has put forward its proposal for the Digital Markets Act, or the DMA. And during the course of this year, the CMA has stepped up with its Regulators Cooperation Forum. It has also opened its DMU, the Digital Markets Unit, that's been operational since April. And the CMA has also opened separate investigations into Google and Apple. So what I wanted to do in the time that I have is really just to compare the CMA's proposals with the DMA at the EU level to discuss how this new regime might apply, because obviously platforms and online providers are going to be caught by both the UK national regime and the EU one. So I think it's useful in a post-Brexit analysis to see what are the overlaps and potential divergences of those two regimes. And I'm conscious that you're glued to your screens and you can zoom in on Zoom. So there's a lot of information on these slides, but I wanted to present really the four main pillars that are the core of the CMA's new regulatory regime. Part of that, if you see number one, is they're going to use their existing merger and consumer protection powers, but they are going to expect a notification and standstill for mergers, because in recent years, powerful players like Facebook and have managed to buy up smaller innovative movers, and there's concerns that the merger regime is not really fit for purpose to capture those type of transactions that fall below the notification thresholds. So there's going to be more intense scrutiny of mergers to make sure that there isn't a consolidation of market power organically through acquisitions. That's one aspect. The other aspect is to use more pro-competitive interventions. I'm going to come to that later. The third aspect is the introduction of what's known as the SMS regime. This is strategic market status, and the CMA identifies this as an operator that has entrenched market power that's been maintained over a period of time that gives that operator a strategic position in the market. And it's identified a number of criteria that are sort of indicators of SMS status. Firstly, that its conduct has widespread significant effects, either because of the number of users or the number of business operators that are reliant on those services, that they provide gateway access to consumers or an important input for businesses. The CMA also recognises that popular platforms such as Facebook or Apple or Google, they create their own ecosystem, so that once you've bought into a system like the Apple phone or the Apple iPad, the consumer becomes very, very reluctant to leave it and switch to an alternative provider like an Android, and vice versa. So there's a sort of captive eco environment that the consumer buys into and then becomes sticky and reluctant to switch. But at all times, they are focusing on the evidence to drive this assessment and analysis. They're targeting their approach and adopting a forward-looking approach. And once the SMS operator has been identified, they're then going to be subject to a code of conduct, which the CMA wants to establish, with clear requirements into transparent dealing, the use of consumer data, not just consumer data, but also business users' data, so that platforms can't use their customers' data to then either use for their own purposes or to use it and combine it with their own data to then improve the quality of their services. They want to make sure that there are clear choices on advertising, that there are no exclusivity restrictions, and that, again, these operators avoid terms that would be regarded as unfair in the consumer sphere. So making sure, again, transparency, but making sure that there's no misleading or unfair terms. The CMA proposes that it will have powers to suspend and block services if the operators breach this code of conduct, and there will be penalties for non-compliance. But it's key to differentiate this from an antitrust regime. This is going to be an ex ante regime that sort of blends competition law with consumer law and draws parallels from other regulatory spheres as well. And that's where the last piece of the jigsaw, the pro-competitive interventions, comes in. What the CMA is proposing is to model Ofcom's ex ante SMP powers that they use in the telecom spheres to be able to step in to a market before the harm has arisen, to anticipate the harm and actually impose measures. And I've listed some of them on the slide, but they're really trying to either control the use of data, promote consumer choice, using the FRAND obligations to force non-discrimination, fair and reasonable pricing, also ensuring that apps which are come onto and use the App Store or the Play Store are interoperable, so that the business users that are on there can actually conclude transactions and take money directly from the consumer without having to go via the platform in order to conclude those arrangements. And then, of course, there will also be more consumer-focused measures, such as controls over unlawful content, and avoiding scams, avoiding fake news, avoiding other harmful content. And there will also be quite strong measures that Ofcom, the CMA, in conjunction with Ofcom and ICO, can step in. So this will not just be controls over the business operation, but they could even go as far as functional or operation business separation, similar to what Ofcom has done with BT's operations, where it felt it wasn't delivering effective services for consumers because of the links between various different aspects of its business. So that's a sort of snapshot of the CMA's regime, and I just wanted to contrast that now quickly with the Digital Markets Act. And what I've done again here is just to put the main provisions of the proposal. If you click on the blue hyperlink, it will take you to the Commission's proposal if you do want to have a look at it. But you'll see there are a lot of similarities here. So rather than the SMS status, there is a designated gatekeeper that will be identified if they have the three main criteria: an entrenched market position, a significant impact in the internal market, and if they provide core platform services. And there's a definition of those core services in Article 2, but effectively they cover many of the things we've been discussing: search engines, social networking, advertising, video sharing, and cloud computing. So again, you can see the parallels with the SMS status here. Interestingly, the EU framework does apply a presumption. So once the operator has its turnover above 6.5 billion over a set period of time, or over 45 million active users, again within a certain period of time, they will be presumed to have that status. And once they're qualified as that, they then fall into the obligations in the DMA proposal. There is a blacklist of what are called no-no obligations that gatekeepers are not allowed, which are sort of automatically considered to be unlawful, which again, familiar themes that we've seen from Iona's talk: no self-preferencing, no combining data, no exclusivity or mandatory requirements to use the services in order to get access. And then there are other types of conduct which are subject to review, so that on a case-by-case basis. So again, these are specific types of conduct which there have been complaints about, which will have to be assessed individually. And I've listed those under that bit.
Thanks very much, Anneli. Can I just move along a little bit? I don't want to run out of time, but that's really great. Thanks very much. Gaucho, can we move to you? Thanks.
Thank you very much. And just building on both what Iona has presented and Anneli's explanation just now, it is worth sort of taking a small step back and consider some of the new legislative proposals that are working their way through the parliamentary system that will also affect the wider digital economy and which have a direct impact on Ofcom's remit and the scope of our work. I'm thinking here in particular of the online safety bill that Vivian mentioned just a second ago. There's also already in place and in force regulation of video sharing platforms, and the two relate, as I will explain in just a second. And then finally, the government is now has presented a bill to Parliament, which is now due to its third reading, on new telecom security obligations imposed on network operators to improve critical infrastructure from technical threats such as cyber attack and other types that might affect the functioning and resilience of networks in the UK. It is worth just taking a small pause and think what are the specific features of these new proposals that have parallel elements to them. The first key thing to sort of note is Anneli mentioned our S&P regime in the telecoms sector. The idea there was that national regulators would be well placed in injecting strong competitive dynamics in existing sectors where those dynamics were compromised for different historic reasons. In that context, we had a broad framework in which to adopt policy decisions, policy interventions to achieve that competitive dynamic. And in these new frameworks, that will not be the case. So we will be applying the rules as they have been set by Parliament, and be less sort of, shall we say, creative in our own policy interventions. So it will be far more of all of these regimes are far more of an enforcement compliance reliant intervention by the regulator, rather than the regulator driving the policy determinations that then shape the sector, if that makes sense. So there's no vision that the sector as it is today needs to move to a different place in terms of its competitive dynamics. It is, if you were to use a shorthand term, it is conduct regulation rather than structural regulation. So when we, for example, briefly consider the telecom security legislation, what government is proposing to do in primary and secondary legislation is set minimum standards, security and resilience standards that telecoms operators need to meet, and they will be set centrally. So where today the current regime is a bit more, shall we say, dependent on the telecoms operators' own assessment of their own risks, technical risks of their networks, that will now move to sort of a, shall we say, a standardized level to be achieved by all. And that's all I propose to say about that particular regime, unless there are specific questions on it. If we then turn to video sharing platforms and then online safety bill, the video sharing platform regime, or VSP regime, is now in force, and it shares some characteristics with the proposals in the online safety bill, but there are also some significant differences. The first difference to point out is a jurisdictional one. So what these obligations apply to are sort of user-generated content or services that allow users to upload their own films. You know, you're perhaps familiar with TikTok or YouTube, etc. And then there are some minimum requirements that go towards protecting end users, adults, children, while also, of course, making sure that the freedom of expression rights are appropriately practiced. The key thing here is that both the VSP regime and proposals in the online safety bill are all about practices that apply to how content is treated once on the platform. What these regimes do not do is introduce content regulation, where there is a regulator that assesses the nature and legality, say, of a particular piece of content. What we are called to do is to ensure that the service providers have all taken appropriate measures to protect users from harmful material. So if we turn back to the jurisdiction point, and if I try to do a very rough and ready comparison between the two regimes, the VSP regime and the proposals in the online safety bill, first I would point out as a temporal element, the VSP regime should be as a precursor to the online safety bill, in that it will be repealed once the online safety bill comes into force. And so where the jurisdiction under the VSP regime is quite limited, there are some, you need to fulfill a certain number of criteria that establish a nexus to the UK, either through establishment or the number of, or whether you're direct, you're primarily addressing your services to UK users, because it stems from a EU directive, and so jurisdiction is obviously shared with EU member states. And so we have, there may be a number of VSPs, providers that are established across the EU, where UK users may be accessing those services, but they do not fall under the jurisdiction of this particular piece of legislation. So some of the, if I were just to focus briefly on some of the key safeguarding measures that are set out in the VSP regime before turning to the online safety bill, there's basically a closed list of measures that are set out, and it includes certain expectations of what to the terms of conditions applicable to the use of those services, and transparency obligations on the VSP providers. Also, elements such as parental control systems and ensuring that there are complaints mechanisms in place so that our end user can raise concerns about a particular piece of content and understand how is that complaint being treated by the VSP provider, or alternatively, if an end user has had their content removed from the platform, that there are clear and transparent processes in place that allow the user to raise concerns about that removal and understand better why that happened. If we then turn very briefly to some of the key features of the online security bill, again, a key feature here, I would just like, I feel I can't stress this enough, it is again not a piece of legislation that is intended to regulate individual pieces of content. It is again entirely to do with the safety measures and processes in place that are intended to protect end users from potentially harmful material. And just a couple of observations here. The bill roughly identifies 3 types of content that it applies to. There's clearly illegal harm. And if you were to just look for examples, it is content related to terrorism issues or abuse and exploitation of children fall in a clearly awful type of content. Then there are measures related to the safeguarding of children. So this is particularly if you have a service that is particularly addressing itself to children as users of its services, it then has a number of obligations, safeguarding obligations it needs to meet. And then there is the wider category of what you could call legal but harmful content. That is mainly about protecting adults against certain types of harm, and that could include, in a relatively recent addition to the bill, issues around economic harm related, as was mentioned earlier by Anneli, around scams and other types of online fraud, which we have seen quite an incredible spike of in the context of the current pandemic. Just to contrast it briefly with the VSP, the scope of this regime from a jurisdiction perspective is much, much, much wider. And under both regimes, Ofcom has extensive information gathering powers and enforcement powers. And just to sort of point out one quite novel feature of these powers, we will have the ability under the online security bill to impose an obligation on platforms that have been found in breach of their obligations to adopt technology to identify and ultimately remove certain types of content, in particular illegal content, so the particularly bad stuff. So what we're seeing here, just to take us, just to have some final comments on this, what we're seeing here is some, very innovative, very creative types of legislation that are coming in, and this is not just the UK doing this. We're seeing, this is a global dialogue happening where we're seeing different approaches to try and tackle the same type of issue. And it takes me back to the very first stages of, as the antitrust tsunami overwhelmed the Western economies, we see different approaches, and I can but imagine that over time we will also see growing out of these different approaches and the learning loop that flows from that, some convergence across these regimes, driven not least by regulators and governments, but also by the stakeholders affected by these obligations. Thank you.
Am I good to go?
Yes, go ahead, Rhodri.
We're now moving from the fairly wide scale and in some ways slightly abstract to something much more concrete, namely attempts by businesses to use particularly the antitrust competition rules to control the tech giants. And over the past few years, particularly the UK courts have seen a number of such attempts, particularly against Google, alleging abuses of a dominant position, or also some data issues, which I'll mention very briefly. And although the cases have been limited in their scope to the UK or the EU, they've also involved challenges to global policies implemented or having effects within the UK or the EU. And obviously, Anneli's already mentioned the time aspect, both of legislation or regulation. And clearly the quickest and the most direct way to control the tech giants would be if the UK courts, or indeed any other national or international court, were prepared to grant an injunction or alternatively damages against them for threatened or actual breaches of UK or formerly EU competition law. However, those possibilities present very significant challenges
for any national jurisdiction, particularly for injunctive relief, controlling the future conduct of tech giants who are in practice generally controlled from California or increasingly from China. And I'm going to illustrate the difficulties by reference to two specific cases, the first of which I was involved in, and second of which Iona has already referred to, which is currently being litigated in California, but which came before the CAT very recently and I think is pending in the Court of Appeal, if I understand correctly. The Unlock case concerned an app which embodied some very cunning proprietary technology which allowed advertisements to appear on an Android phone when you turned it on and before you reached the Google main home page. And that could potentially have allowed Unlock to give benefits to users in return for accessing these adverts and providing data to Unlocked. But it would have done it independently of Google. And the Epic case concerned a very successful video game supplier, including the Fortnite game, who devised a mechanism and offered a discount to consumers based on using their direct payment platform rather than the Apple or Google payment platform. So there were common features to these cases. They were both radical attempts to bypass key elements of the Google or Apple regime, and they illustrate the global reach and what you might call the judge and jury nature of access to the Google or Apple operating systems and app stores. In effect, those wishing to use the Google Play or the Apple App Store have to comply with the rules imposed by them, or they're exiled from the relevant tech kingdom without any effective recourse. And those of you who are Shakespearean fans may recall how King Lear banishes Kent summarily from the kingdom of the UK, and effectively that's the power that Apple and Google have to banish you from their app stores, which is a very major commercial problem for almost anybody. And in Google's case, the control over the Android operating systems reinforced by the fact that I think has already been mentioned, Google has an extremely powerful and very, very profitable advertising, online advertising system, which in practice controls access to online advertising. So both Unlocked and Epic felt the full force of Apple and Google's wrath by being removed from the Google App Store, Google Play, or the Apple App Store. And in the case of Unlocked, it was also threatened with removal of access to AdMob, which is Google's advertising service. The effect in Unlocked was immediately to destroy the Unlocked business worldwide, and that remedies are still being pursued, I think, in the US by administrators, whereas Epic is a much larger and more successful business and is apparently seeking to appeal and is currently litigating in the US as well as in the UK. In each case, injunctive relief was sought in the UK courts or in the CAT in the case of Epic, but with very limited success. And the common issue in both cases, if I can put it in the way that Mr. Justice Roth put it in the Unlock case, is whether the UK courts could be invoked to be the effective competition policeman for the world. And that was a role that Mr. Justice Roth politely declined. And there are essentially three issues that arose in both those cases. First of all, the question of jurisdiction, or whether the substantive case to be pursued. And that raised the question of whether UK courts have jurisdiction to control the tech giants in relation to their global policies, insofar as they have effects outside the EU or now outside the UK. Secondly, conditions for service, which raises the gateways, which I won't get into given the time, for service out of the jurisdiction, and in particular to Google subsidiaries or the Google parent companies or the Apple parent companies outside the EU or the UK. And thirdly, whether the UK courts are in fact the suitable forum for litigating even UK competition law. And these issues, of course, have now been aggravated by UK withdrawal from the EU, so that the primary jurisdiction, and in fact the sole statutory jurisdiction of the CAT, is now UK competition law. This was not really a problem in Unlocked, because that arose in 2018 when the UK was fully a member of the EU, albeit in the departure lounge. And in Epic, they managed to issue the proceedings just before the end of last year. So as far as service out was concerned, the Irish subsidiaries were still within the scope of the old EU regime. And so, but now you would be looking at the position essentially exclusively under UK law. So Mr. Justice Roth took a cautious approach on all three issues. He said that the jurisdiction or serious issue to be tried question related solely to effects within the EU, or now the UK, and that particularly in Unlocked, the fact that the global policy would have the foreseeable and in fact actual effect of destroying Unlocked's business globally, and therefore also destroying its business in the UK, was not a sufficiently direct effect to justify exercising jurisdiction over that policy as a whole. Secondly, that the gateways for service for the same reason were limited to the effects within the UK. And in Epic, and that's relevant to the fact that litigation is ongoing in California, Mr. Justice Roth also found that the suitable forum test was not satisfied, and that it was more suitable even for the UK competition law issues to be addressed in California rather than in the UK, because of the location of the principal witnesses, and Epic was an American company, so that all the witnesses were in the US. And you might contrast that, and I think we briefly mentioned that, to the consumer cases that have been heard by the UK courts. First of all, Lloyd and Google, where there's been a representative action which is currently pending for judgment in the Supreme Court, arising out of data breaches. And there's also a new Apple case, I think has already been mentioned, which I think is similar to a case called Apple and Pepper, which was litigated in the US up to the Supreme Court there, and is also a question about the Apple commission payments that are received, and whether that's too expensive. And so where direct consumer harm is demonstrated, then the UK courts are willing to act, but it's clear that in relation to the larger policy questions, they've been fairly circumspect. So I'll just close with some questions which arise out of this. First of all, the general question of policy, whether could or should the UK courts exercise jurisdiction over the tech giants at the policy level, in a similar way to the way in which the Commission was prepared to act against Intel, at least in a regulatory position. Will the UK's departure from the EU either embolden or possibly inhibit the UK in performing any such international role? And I guess that impinges on the question of the global Britain aspiration of the courts as part of the UK's general policy. Will similar issues arise in relation to the non-US tech giants, and in particular the emerging Chinese or possibly Japanese or even EU giants, if they might emerge in the future? Would they be similarly cautious in relation to merger controls, so that they will only restrict conduct insofar as it affects the UK? And will that limit the jurisdiction of the CMA or the English courts? And then last two questions, and if, I think following the logic of Mr. Justice Roth's judgment, if the UK courts can't control the tech giants, then who can? Essentially, he's passed the issue of controlling Apple to California, but I think on the logic of the judgments that he's given so far, or the courts have given so far, the Californian court would equally lack jurisdiction to control the conduct of Google or Apple insofar as it bore on non-US jurisdictions, in particular the UK, and insofar as it was prepared to exercise jurisdiction, the final question is, would the US courts, or in due course the Chinese courts, exercise any control over UK competition law following the same principles that the UK courts themselves might apply if they were doing it themselves. So that's quite a speedy coverage of quite some large policy issues, but I think we're likely to see some of them at least litigated over the next few years in the English courts.
Yes, thank you very much, Rhodri. Thanks to all our speakers. Absolutely fascinating, different insights into the issues and challenges that are thrown up by this brave new world that we find ourselves in. I think we've got time perhaps just for one question. And this follows on nicely actually from your from what you were saying, Rhodri, although I suspect that Anneli might be best placed to talk about this, respond to this. There's been a lot of discussion by you all about behavioural remedies and the focus on controlling conduct. But in the Q&A, there's a question that do structural options also need to be considered? Or do the sort of global nature of these businesses, which Rhodri has already explained, seems to be influencing the ability of the courts here to grapple with them. Do the global nature of these industries make structural options impractical? Perhaps Anneli, would you like to come in on that?
I think it's a very difficult one because we're dealing with a whole range of different conduct and features here, and I think Iona's analysis at the beginning that some of this is due to the actual features of the way that these markets have developed organically. Other things are a combination of conduct and the features of the market. Structural remedies are very much a sledgehammer to crack a nut, and we've seen this in the telecom sector, where Ofcom has adopted an escalating approach. It's gone in with sort of ex-ante powers and penalties and dispute resolution until it came down to the final against Ofcom and Openreach of business separation, which is a very, very draconian measure. And I'm just worried that in this fast-moving, innovative sector, that sort of measure is so heavy-handed, it could actually stifle innovation and investment in this area that needs that investment as oxygen. 20 years ago, Friends Reunited was the key platform. Now we know Friends Reunited is a different thing, but it was very rapidly taken over by Facebook, and we can anticipate that some of these giants that we now have will change. So you don't necessarily want to stifle them through structural measures. And I think that the aim of this is to create other ex-ante measures that might be more targeted and proportionate.
Okay. And perhaps just a word perhaps from each of you very, very quickly. Do you think that digital platforms are actually presenting brand new harms, brand new conduct, or is it the old forms of anti-competitive conduct just on an enormously vast scale and slightly different in nature? We are running out of time, but I just really want to hear the answer to that question. Start with Iona quickly.
Yeah, thanks, Adrian. Very quickly, so the others have a chance to. I don't think they are in the broad sense. I think what is interesting is the features of these markets mean that we cannot necessarily assume that the same types of conduct will have the same impact. And if you think about something like predatory pricing in a market, a two-sided market where you've got zero pricing on one side, that actually or below cost pricing on one side, that's actually allowing the platform to compete more aggressively on the other side of the market, could actually be pro-competitive. So yeah. I think it complicates the analysis of them. I don't think necessarily we've seen to date a whole new sort of raft of types of conduct. It may change though. I mean, that's for now. There we go.
Anneli, quick.
There's a lot of familiar territory, exclusivity, excess pricing, tying. They're very, very familiar. I think there's two aspects that are new. One is evolving data and use of data, which is a sort of bolt-on. The other one is the conflicts of interest. And I think it's because many of these platforms actually compete directly with their main business customers. And so it creates leveraging opportunities that perhaps we haven't seen so much of or thought of in abuse terms before.
Okay. Gaucho, do you want to put in a couple of words on this point?
Well, I mean, I think it was just in the parallel sectors of harm where we're seeing conduct that is that has an impact on end users, so not outside the competitive dynamics. We are seeing new policy issues arising that are, as you say, Vivian, to do with scale and the global nature of some of these services that create new challenges for us to consider.
Rhodri, last word to you.
Well, I can't resist referring to, I think the first case that you and I ever did together was a case called Tetra Pak, where Tetra Pak presented itself as a benefactor of mankind because of its marvelous system.
Not.
It in fact made a lot of money out of selling cardboard.
Yeah.
And I suspect that one needs to follow the money with the tech giants as well and realize that they're in fact very large, very profitable advertising companies, and they sometimes masquerade as free search engines and other free benefits. And I think the commercial side of it needs to be borne in mind.
Yeah, thank you. Yes, on this free business, which of course is a strange aspect of it, I recommend to everyone watching, if you haven't read it already, Professor Dan Ariely's book, Predictably Irrational, and his chapter in that on the power of zero, and how the fact that things are free has such a great influence on behavioural, on what choices people make. Thank you so much to our panelists. That was absolutely fascinating, and this is clearly going to be a topic which I'm sure will be featured in conferences for many years ahead. It seems a very fertile and interesting area for developments of the law. But it's now my pleasure to hand over, I think, I'm not whether Philip wants to come in or whether I just hand over directly to the next panel, which is Sir Stephen Richards, on a topic which is very close to the heart of everybody who's watching this conference: cross-border services, practice rights and establishment under the TCA. But thank you very much again for all our panel members.
Very much.
Thank you, and thank you, Vivian, for chairing so expertly. And I completely agree. I think we've seen the future. I come on really only to act as the man who sort of moves the scenery between the acts at the theatre. And I'm going to briefly pause while I move the new panel in and this panel out with thanks. Resume recording, and the chair of the next panel, which has been announced by Vivian, is Sir Stephen Richards, the former member of the Court of Appeal, again well known to all at Beg, a former Treasury Devil, and at the time of your retirement you were Deputy Head of Civil Justice. You've sat occasionally since in the Court of Appeal, and I'm told since 2018 you've been a justice also at the Astana International Financial Center Court in Kazakhstan. So I hand over, Stephen, to you.
Thank you very much, Philip, and welcome everyone to the second session of the afternoon, which, as has already been advertised by Vivian Rose, deals with the subject of cross-border services, practice rights and establishment under the Trade and Cooperation Agreement. We have another excellent panel of speakers. Going first will be Evanna Fruithof, long-standing representative of the Bar Council in Brussels, and one of the linchpins of these Beg conferences. She's going to provide an overview of the practice rights position under the TCA itself and the withdrawal agreement so far as still relevant, and an update on what the Bar is trying to achieve with regard to mutual recognition. Evanna will be followed by Adrian Berry of Garden Court Chambers, a specialist in the fields of immigration, asylum, and citizenship law, who will provide a complementary explanation and update on EU-UK migration and what practitioners need to be aware of. And the final speaker will be Fergus Randolph QC of Brick Court Chambers, an EU law and competition law specialist, who will provide a yet further practitioner perspective on what all this looks like in the working environment, considering the issues that have arisen so far, and what we may expect as travel restrictions ease and we resume so-called normal service. You will hear from the panel speakers in that order, and we'll see what time we have for answering questions at the end of the session. But as before, if you do have a question, can you please type it in as we go along by using the Q&A button at the bottom of your screen. With that, I hand over to Evanna.
Thank you very much, Stephen. Good afternoon, everybody, and thanks so far to everybody else for a really terrific conference. I'd like to start actually by just wheeling back a tiny bit in time and just making quite an obvious point, but it informs everything that's happened since. And that is that it would have been possible for the UK to leave the EU without leaving the single market. And had it done so, this entire discussion would have been rather different. But that isn't, of course, what happened. And as soon as it became clear that from the UK's perspective, leaving the single market was a red line issue, it also became clear from the EU's perspective that the EU member states and the EU itself, as a consequence, the Commission itself, therefore, would hold tight on ensuring that the UK didn't get to, as they said, cherry pick the best bits of the single market. And we all know, because we benefited from it for very many years, that one of the best bits of the single market, certainly in the services field, was the lawyers regime. It's the most, it still is the most advanced for any service sector, both in terms of the Establishment Directive and the Services Directive. And it also, of course, benefits from the Mutual Recognition of Qualifications Directive, which is cross-sectoral. So that package is unique, and lawyers have done very well from it over many years, including UK lawyers. And indeed, of course, UK lawyers have been particularly good at benefiting from that regime, and that fact in itself wasn't lost on the EU, isn't lost on the EU. So when I say, talking about not cherry picking the best bits of the single market, it is very much from the EU's perspective, one of those best bits that we are looking to try, or we were hoping to try to retain. But against that background, therefore, it became pretty clear to all of us working on these issues on behalf of the Bar, including members of the, as it was then, the Brexit Working Group, now the Future Relationship Working Group, soon to be the International Legal Relations Working Group of the Bar Council, that we needed to try, so far as was possible, to advise members of the Bar to try to preserve their practice rights ahead of full Brexit, as in the end of transition, because we were not that optimistic that the TCA would provide very much in this field. And it turned out indeed that was wise counsel. So if I go just very quickly through the withdrawal agreement, just to remind you all that under the withdrawal agreement, indeed, there were practitioner-specific and case-specific bases upon which practice rights could be, as it were, retained after the end of the transition period. So if you were, before the 31st of December last year, called or had pretty much completed your application to be called to an EEA bar, and you benefited from an EEA nationality, then your practice rights effectively were pretty much unchanged from overnight when we left at the end of last year fully. If you were called or had completed your application properly to an EU member state bar but did not hold an EEA nationality, then your practice rights in your member state of call, based on your host title, and also your practice rights before the Court of Justice, again based on your home title, again were pretty much unchanged. But your right to practice in other member states of the EU, it then becomes rather more complicated because of the fact you don't hold EEA nationality. And then the other category of practitioner, as it were, that was protected, provided you acted quickly and before the end of the transition period, are frontier workers. It's a little bit more of a grey area, but there is this category of persons who needed to have had an establishment in another member state. And it would appear to be the case, but it depends from one member state to another as to how they've interpreted these provisions, that you had regular, you were practicing a regular activity in that member state on a reasonably lengthy, for a reasonable length of time. And that is an area where we don't think there are all that many practitioners who would fall under it, but it is still a bit of a live question in relation to some practitioners and some member states. So And indeed, it is the case for one or two member states in relation to those three categories that there are still problems arising and some question marks about the status of the practitioners, and the Bar Council is trying to assist in those cases where those issues are still arising. Obviously also, which is relevant to many of the people involved in this conference today, those of you who are instructed in cases that were pending before the Court of Justice at the time of the end of transition, or who are instructed on questions involving the interpretation of or breaches of the terms of the withdrawal agreement for the next 8 years, or for 8 years from the end of transition, also potentially, you also still have your rights of audience before the Court of Justice. So those are the sort of categories that are still protected. But for basically everybody else, if you didn't manage to take advantage of the withdrawal agreement in time or at all, then you are looking now at the provisions of the Trade and Cooperation Agreement as fully ratified very recently, as we all know. And unfortunately, the news is really not very positive, again, as I know you all know, but I will just go through that very quickly because you'll get more detail from my learned colleagues who come after me on it. But basically, if you are UK only qualified and you are self-employed, and I am basically looking at the position for self-employed practitioners, there's a lot of advice out there for those who are in employed practice, those who are working for law firms, especially the Law Society's own website has a lot of advice, but we too on the Bar Council, and I definitely encourage all of you to look at the Bar Council's website, and we are trying to keep that up to date. But basically, under the TCA, the best fit for the kind of practice that most practitioners do cross-border in and into the EU is that of independent professionals, which has a specific definition under the terms of the TCA. And for those, the TCA commits EU member states as a minimum to allow you to provide clients with legal advice on domestic, that is UK law, and public international law based on your home title in and into the EU territory. And I say that to cover the different modes of supply under the GATT. Subject to local registration requirements, reservations, and relevant mobility provisions, which Adrian will get onto shortly. Where registration is a requirement, the terms of that should be as favourable as for any lawyer from any third country. There can be no requalification to domestic qualification linked to that, or a requirement to establish a local office. Again, provided you are only talking about advising on UK law and public international law in the territory concerned. For junior self-employed practitioners of less than 6 years professional experience, I'm afraid even that isn't available on a fee earning basis because the IP definition is too restrictive. And there is no positive commitment in the TCA, and this is important, to permit barristers to provide advice on EU law or, with limited exceptions, to provide representation services on EU territory. But of course, individual member states can, and indeed do, have more permissive regimes in relation to both of that. So basically, and just one other thing on a sort of general level, the TCA also contains a carve-out for legal arbitration, mediation and conciliation services based on home title when performed on a fly-in, fly-out basis. So here I am primarily talking about court appearances. And representation work that's not in that category. So all that to say, basically, what you have to bear in mind is that under the TCA, you have no actual active right to provide legal advice on EU law or private international law or representation services in any field of law on EU territory. That's the sort of starting position. But individual member states, as I said, can grant both, and therefore it's up to individual practitioners, unfortunately, to check the position in each member state. And as I've mentioned already, the Bar Council and Law Society websites do have links to a lot of that information, also via Her Majesty's Government websites and via the European Commission, which has also provided a lot of links to this sort of information. Our member states vary enormously in what reservations they have and what services they will and will not allow third country lawyers to provide in and into their territory. Belgium is one of the more liberal, and Greece is at the other end of the spectrum, although, again, there have been teething problems in relation to these questions too, which Fergus will go into shortly. They also vary as to the sort of services they have reservations on. So, for example, France has a liberal regime when it comes to arbitration and mediation services by third country lawyers, but does not permit them audiences before its courts. But again, Fergus will go into that in more detail. So the other question, of course, is if you do not hold an EEA nationality, you have to check the visa and work permit requirements, and Adrian will go on to that. You may have heard anecdotally that United States attorneys have been nonetheless rather freely providing their legal services across the EU over many, many decades, and that is true, but there is an expectation, and I'll get to this shortly, that might also become trickier because the member states are likely to be more sensitive about this in the context of UK practitioners going forward. Just a couple of other things to raise just before I go to a couple more points. You need to be aware, above and beyond what I've just cited, of the fact that if you are giving EU law advice, whether you're doing so from the UK or on the territory of EEA member states, it's prudent to always have the advice countersigned by an EEA qualified lawyer, just as an additional safeguard. It's also prudent to look at, on a case-by-case basis, for other practical questions such as professional indemnity insurance coverage, VAT and data exchange. We know that although it looks as though the EU is likely to give a data adequacy decision in favour of the UK, the European Parliament, as was mentioned earlier today, has put a bit of a spanner in the works on that. I'm going to cover that in the next Brussels News in some detail, so those of you who get that, please look out for it. I'll be giving links and information on that in that. Obviously, also the other thing is we don't yet know how all this is going to play out in practice, but Fergus is going to have an attempt to look at the in the crystal ball on how it will be once COVID is finished. Can I just very quickly before I hand over just say look at solutions going forward to this, given that the rights are rather restrictive under the TCA. First of all, some member states do have recognition for foreign legal consultants. That varies a lot between one member state and another. France has just been revising its rules, but again, it's pretty good, it's pretty liberal. Check on their website for the information on that. You can literally Google and find links directly. The CJEU is, in fact, this week I was involved in a meeting where they were looking at the question of whether there ought to be a sort of minimum standards agreed by the members of the bars of the CJEU across Europe on what the status of foreign legal consultants should look like. But my impression is that there are too many bars that would be not keen to take that step, and so it's unlikely to come together. Then, of course, we've got routes to mutual recognition of professional qualifications. The TCA itself does under Article 158 and Annex 24. It sets up guidelines and the provision whereby an MRA can be set up between the UK authorities and the member states. But all 27 member states would need to support that. And in the legal services field, it is considered unlikely that that would be the case, although there would be a potential drop down to an equivalent, shall we say, to the general directive on mutual recognition of professional qualifications, which would be a potential alternative that could also be created under the MRA, but it's early days. We don't yet know what that may look like, but we will stay very engaged on that. We're also exploring, as you might expect and hope, the possibility of mutual recognition agreements on memoranda of understanding with individual member states, both bilaterally and on a multilateral basis. And there are live discussions underway with several priority jurisdictions. For those to work, of course, there's a very strong element of reciprocity, as you would expect, not only in relation to the regulatory requirements of the regulator concerned, in our case, the Bar Standards Board and the Legal Services Board and the SRA on the solicitor's side, but also Home Office, because there's no point in us being liberal in terms of what we offer or agree to offer to incoming lawyers in the UK if they can't actually get in because of Home Office requirements that don't let them earn fees or require us to prove that there's a gap in the market that they need to fill, etc. So just to close, I just want to say, and it's something that anybody who works closely with me or reads anything I write knows rather boringly I say a lot. The mutual trust element of all this is really crucial, and it has been undermined looking at it from the EU perspective, both in the IMB context last year, now in the context of the Northern Ireland Protocol, which we'll be hearing more about later on this afternoon, the grace periods unilaterally extended, etc., on the UK side. And if you look at some of the debates that have taken place, for example, on the adequacy question on the data side in the European Parliament, you'll see the extent to which the concerns are held by EU officials, but also in the member states' capitals themselves. And the EU has been very clear that they're not intending to reopen any of the agreements, whether it's the withdrawal agreement, the Northern Ireland Protocol, except insofar as there is some flexibility built into the terms of the treaty as agreed, and also the TCA itself. But they are now looking to apply and implement it as well as possible. So just to sort of say that if you're looking at the knock-on effects of the various trust issues and the other background noise that we hear so much about, I note that the European Council is going to be meeting on Monday and Tuesday of next week. And the UK has been put back on the agenda. It wasn't intended to be, but it is now on the agenda. There will be a debate about EU-UK relations. And one of the things that we are being told in advance of that meeting is that the member states will be reiterating the fact that they do not want any erosion of the single market. And they specifically highlight professional services and mutual recognition agreements as being an area where they are concerned about UK efforts to enter bilateral agreements with the member states. So I highlight that just to say that there's a link up across all these different issues in relation to the whole background trust atmosphere, as well as to the actual terms of the agreements per se. And now I, with great pleasure, hand over to Adrian. Thank you very much.
Thank you very much. I have a screen to share, so bear with me just for a second while I get it going. So hopefully you can all see this and hear me. I'm going to take you through not mobility rights that are protected under the withdrawal agreement or frontier workers, but the new mobility regime under the trade and cooperation agreement, particularly as it affects independent professionals, which of course self-employed barristers would come under. In everything I say, you need to bear in mind that, of course, each EU state will have its own local immigration rules, which can be more generous, even in the areas which fall within the scope of the trade and cooperation agreement. And that also there's a whole range of mobility provisions which will apply potentially to barristers and other professionals under local laws, which are not within the scope of the agreement. And so the agreement effectively covers short-term service provision in its various guises, and it creates routes by which you can migrate. And those routes have to be embedded in the domestic immigration laws of the countries in question. And so where you have a treaty commitment to a short-term service mobility provision, it then is embedded in the law of the immigration rules of the state in question, and therefore can't be revised at discretion. That's the advantage of it. But much of what we see in the mobility provisions adds very little to existing provision in some respects, particularly in respect of short-term business visitors. So always remember that when you're looking for a route, you're really looking at the state's immigration rules, and some of that will be derived from the trade and cooperation agreement. But if you want to come and take a fee on a very short-term basis to travel visa-free from a client in a European Union state, the trade and cooperation agreement doesn't make provision for that if you travel as a short-term business visitor under its provisions. But of course, for example, every state will have its own visitor rules, and some, like the UK, do allow you to come to the UK as a visitor and take a fee from a client in the UK for a month if you're providing advocacy services. And that's known in the jargon as a permitted paid engagement under the visitor rule. Also, if you want to go for residence, for employment, or for establishment as a self-employed person, the trade and cooperation agreement adds nothing, but of course each state will have its own provisions. France has provisions for members of the liberal professions. So always bear in mind that these rules act in parallel or embedded in local rules. And then also that some states make distinctions between permission to work and residence permits. In the UK, the skilled worker visa rolls these two things together, but it's quite common in many countries for these two forms of permission to be separated. So the other thing is that under the routes that we're going to consider for independent professionals and for their employed counterparts, contractual service suppliers, the trade and cooperation agreement allows people to come for up to a year, as we will see, but it doesn't prohibit the imposition of a visa requirement or a sponsor requirement. So we know that on an inbound basis coming into the UK, the Home Office requires people to have a sponsor, and that could be the person in this case who is receiving the service rather than the employer in the traditional sense. So the UK on an inbound basis has chosen to have both of those requirements. When you're looking at the position in other member states traveling as an independent professional, the question will be, do they or do they not require a visa prior to travel? And of course, without a visa, the carrier faces carrier's liability sanctions for boarding a person. So as a visitor, whether it's as a business visitor or otherwise, British citizens and others are non-visa nationals to EU states when they're traveling to visit. They don't need permission to travel before they board the flight. But for the independent professional route, they may do. And so it's important to check the requirements. You'll see that the agreement only covers certain types of economic migration. The one that matters to us, of course, is that for independent professionals, and also to a limited extent, short-term business visitors. There are others there that I put them on the slide so simply so that you can see in case you can see the narrow scope of these things. These are all short-term routes. They're not designed to lead to residence, permanent residence and citizenship. The difference, they could have done, it wouldn't, just because free movement was ended, you didn't simply have to follow a sort of GATS type of approach to short-term service mobility as the only form of economic migration in the Trade and Cooperation Agreement. But this was all that was achieved, and that was all that was agreed. So it is as it is, but you'll see there that there are some things that don't matter to us so much, such as intracorporate transfers and business visitors for the purposes of establishing businesses. Bear in mind that any beneficial route you get under the Trade and Cooperation Agreement still allows the state in question to operate its immigration control system as regards admission, as regards expulsion, and as regards treatment on an in-country basis. And so it's not the case that these rights somehow create any freedom from any of those things. It's still possible to refuse entry on grounds of conduct and to expel someone on grounds of conduct. It's still possible to regulate access to in-country facilities. And in the UK context, where we have obviously immigration status checks in relation to permission to work and permission to open bank accounts, to hold driving licenses, and private residential tenancies. And other countries may have different systems. I'm just put that slide up there in case the slides are circulated so that it's comprehensive. I'm not going to dwell on business visitors for establishment purposes or on contractual service suppliers because they're employees, but I merely note in respect of that, and this is a route to migrate for up to 1 year in order to provide a service or for the duration of the contract, whichever is the less, that this service supply, the professional qualifications there are 3 years, a minimum of 3 years professional experience, whereas as you'll see under the independent professional route, that you have to have at least 6 years professional experience. So this is the route that really applies for self-employed barristers. This is an additional route, in addition to being a short-term business visitor, in addition to traveling to a country and seeking to reside there as a self-employed person under local rules. There is this sort of hybrid economic migration route for independent professionals, which allows you to provide a service for longer than you would be as a visitor, so for up to a year, and it allows you, you mustn't be established in the country to which you are moving to provide the service. There has to be a service provided to a final consumer, and you have to have at least 6 years professional experience. Bear in mind that a lot of countries will have their own, if they want to create an appetizing market, they want to create their idea of their country as a destination for the provision of legal services. They may often have much more liberal regimes. This is simply the commitment that's made under the treaty. So you have to look at this in the context of what a country which is trying to draw services and make itself a destination in the center of a whole range of professional services will probably have a more liberal regime than this. There are provisions again in the Treaty for Intracorporate Transferees, which we're not going to dwell on. It's not relevant so much for us, but just to note that all countries have economic migration categories, or most do, for ICTs anyway, and that what's achieved in the treaty is really very, very minimal. In the UK context, it made almost no difference to the inbound immigration rules that already exist for intracorporate transfers. One of the things, though, that is prohibited when you look at these routes are that you cannot have quotas or impose economic needs tests in those particular categories. Of course, if you look at the UK context, what used to be called the Tier 2 general category, which you might call the work permit category, is now called the skilled worker category. That has a cap on numbers, which is suspended at the moment, but could be reimposed. The difference here is under these routes, you couldn't impose a numerical quota now, as between the UK and the EU. Always bear in mind that there are a number of individual states will have carve-outs or non-conforming measures in respect of each of these routes. And I put the measures there simply for ICTs and business visitors for establishments, so you can see it in that context. Short-term business visitors. This is a route under the agreement. Of course, EU states have inbound visitor categories for immigration anyway. The UK has its visitor rules anyway for people travelling to the UK. The Schengen area has its own Schengen visitor code. And that code, of course, most EU states, but not all, are in Schengen. Some Schengen states are not in the EU, just to complicate matters. And the short-term business visitor route provides something which looks very, very similar. The key thing about both the Schengen visitor rules and these visitor rules is there's no provision to take a fee from a client in the host state, which means you're coming for things other than getting paid by the client in the country to which you travel. And so that limits limits the utility of it. The UK's visitor rules are, in any event, for all practical purposes, more generous than the things which are agreed under the Trade and Cooperation Agreement. So it adds very little, but it may be that in particular EU countries that these provisions do add something. But the permitted length of stay is for up to 90 days in any 6-month period, but the UK allows you to come for 6 months in any event. So that's an example of where domestic provision is more generous. So when you're looking at the visitor entry provisions for when you're traveling to an EU state, you have to think, well, it's not just about what's in the TCA, but also what the state in question does. Bear in mind that if you're traveling even on a short-term visit and you want to take a fee from a client in the host state, just because the Trade and Cooperation Agreement doesn't provide for that, that the state in question may allow you to do that under its local rules. You have to check, or it may allow you to travel as a visitor, but also require you to get a work permit. Now, we don't tend to use the term work permit in the context of short-term visit migration, but other countries do on occasion. And so it sounds a bit counterintuitive. A work permit might be because you're moving to a country to live there, but some countries require them for the purposes of conducting business. But you can see that the list of activities which are allowed for short-term business visitors. So this is where you're traveling visa-free automatically on a short-term basis for up to 90 days. Are all things which are preparatory or build up to or buttress economic activity, but which don't allow you to take a fee from a client for a specific transaction itself. Again, bear in mind, and you can see here an example that some countries like Croatia, Cyprus, Denmark do require a work permit for short-term business visitors, just in case you might accidentally supply a service, or for whatever reason they have carved that out in the TCA. So that's an example of how some jurisdictions may be more meaningful for people on this conference than others, but you can see an example there of how you have to look at it on a country by country basis. And again, for IPs and contractual service suppliers, you can't put a cap on numbers or impose an economic needs test. What it doesn't do in terms of mobility is allow you to use a professional title of the country where the service is provided. You must only move and this is more relevant perhaps to contractual service suppliers, but potentially relevant in a multi sort of team case of independent professionals moving who are working on the same case. It mustn't be greater than the number of people necessary to fulfill the contract, and the maximum period of time for the service provision or for the individual moving on a one-off basis is 12 months, or for the duration of the contract, whichever is the less. There isn't a specific cooling off period in there, so whether you can do these things sort of one after the other with short-term breaks, as used to be the case in when people took advantage of the posted worker regime and when the UK was in the EU, remains to be seen. There may be some creative workarounds in terms of the number of times you can take advantage of that. IPs, and now I'm speaking in terms of what the mobility rule requires, not the regulatory rule. If there will be other forms of restriction on service provision, which are in Annex Servin 1 of the Trade and Cooperation Agreement, which say that there are certain things you can and cannot do in a regulatory sense when practicing as a lawyer in the country in question. These are the restrictions on the things that you can and cannot do in order to get an immigration entitlement under the treaty to move to the country in question to provide the service. So you have to check both. You have to check, well, maybe I can get my immigration permission to enter the country on this basis, but once I'm there, I also have to have a look at Annex Servin 1 and the restrictions there and so on to see what I can do. And also bear in mind that if you want to travel in order to provide advocacy, you may be able to do so under the local law of the state concerned. So this is about whether or not you have an immigration entitlement under the Trade and Cooperation Agreement. And you'll see there that it's limited to legal advisory services, not advocacy in respect of public international law and home jurisdiction law. And then for immigration entitlement to travel, I've highlighted services related to management consulting because that's considered to be a provision where arbitral services would come within that umbrella. But even if this particular mobility route, this provision doesn't assist you in terms of what you're seeking to provide in the country in question, there may be other immigration routes under the state law of the state concerned. So it's not the end of the road because you've looked at this and think that it doesn't help you. That's just a list of provisions for contractual service suppliers. We won't dwell on that. It's much bigger than for IPs that gives you an entitlement to travel. And you can see here on lists of reservations that some countries have, the Czech Republic and Austria, I think, have put restrictions in terms of the maximum period of time you can go for as an independent professional. Or on any basis in all sectors, and then in respect of legal advisory services, there are economics needs tests imposed by a range of countries in order to get the immigration entitlement to travel. Even if this knocks you out because you're in B Roman 2 there's economic needs tests, you might still be able to qualify under local law, which may have become more generous since the country in question entered that reservation when the treaty was being negotiated. So always check the current position. That's it. Thank you very much.
In that case, can I ask Fergus if he will come in with his contribution?
You may, Stephen. Thank you very much indeed. And I hope that you have my slides on screen. Can I confirm that that's the case?
Yes.
Splendid. Good. Well, I'm going to trot through a few points, probably not all of the points that Evanna very sweetly dumped into my lap, but I'll do my best. So this is what I want to start with is the view from the Palais de Justice, the falling down building in Brussels, which might be an interesting analogy with the falling down position of the UK post-Brexit. But anyway, so the first point, I'm all right, Jack, or am I? Tableau Brits. Well, I'm a Tableau Brit, and Tableau Brit simply means someone who is fully a member of the local bar. So I'm an advocate at the Flemish or the Dutch-speaking part of the Brussels bar. And strictly speaking, I have my card and I'm in a case before Luxembourg, and almost immediately after 11 p.m. on the 31st of December of last year, I was asked to provide proof of that fact. Prior to that time, I hadn't been asked to provide proof of that fact. There's one teeny, we should be all right, as Evanna and Adrian have made clear, we should be all right, save for the fact that as Evanna pointed out, there are issues if one is simply a UK national and not an EU national as well, or a national of another member state. If one wants to travel and provide services in another member state other than the host member state where one is established. And so if I wanted to go to Paris, for example, that could be a problem insofar as those of us who are established in Brussels have to have a residence card, and we have to change from an ordinary residence card to an M card. I don't know what the word M or the letter M stands for, but anyway, it's an M card. Now, there is an issue apparently at the moment that the Belgian authorities are a little equivocal about whether the new M card will provide sufficient evidence of residence once those cards have been activated, which would, of course, impinge on one's ability to become a national of, say, Belgium, where one has to prove residence for a period of 5 years or more. So I'm all right, Jack, probably. Another brick in the wall, yeah. List B, this is purgatory. List B is a Belgian construct, and it has little, if any, point, apart from the fact that it's a list. But it is a list with no effect. One cannot use it to plead before, or one cannot use one's presence on it to plead before the Luxembourg court. It is just where those who were on the list E, as in Europe or EU, were moved when they couldn't show, those persons couldn't show, those British or UK practitioners couldn't show that they had either applied successfully to be on the tableau or were in the process of so doing. And so there are some sad souls, some of whom may be on this call, who are in list B purgatory. The Irish job, how many English barristers can fit into the King's Inn Library? Yes. Everybody thought that the Irish option was going to be very good. Certainly for the solicitors, they just had to pay €800 or something, and they got onto the roll and they thought that was lovely, and that thereby they would have their rights of audience and, much more importantly, privilege rights not enhanced but protected. That didn't appear to be the case, and the Law Society of Ireland made clear that solicitors had to be properly established and not just brass plates. The bar in the King's Inns seemed to vacillate for a while, but now it would appear that as long as one pays for one's seat in the library, as well as, I think, one's annual membership, one is okay. But I think watch this space. It's not wholly clear whether one's rights as a UK barrister will be protected going forward. Orchestral manoeuvres in the dark, and you can see a theme here, I hope, of musical knowledge. Orchestral manoeuvres in the dark, yes, the Luxembourg gamut. I am aware of one person who is definitely on this call, who has taken advantage of the Luxembourg bar's more generous approach to be called to the Luxembourg bar. And of course, what better bar to be called to if you want to appear in the Court of Justice and keep your privilege rights. So that's a possibility. And through early morning fog, I see visions of the things to be. Now, those scholars, and I welcome you, the John and Sophie Law scholars, renamed, may not have picked up on the reference to that. That is from the well-known, but quite a long time ago, American series MASH, and the title of it is Suicide is Painless, which some of us may feel strongly about in terms of following Brexit. But anyway, are there, well, certainly there's early morning fog, definitely. Visions of the thing to be, I think it's pretty unclear. And so is it a mashup or a mosh pit? I don't know, but I'm going to segue into the Welshness of some of the people looking after us today, including our president, because the scholars may know that song through the fact that it was covered more recently by the Manic Street Preachers, a very well-known Welsh rock band, so I'm informed. Now, I have to, perfect. No, I wonder if I can, excellent. Good, good. Now, moving swiftly from Welsh rock bands to the rather more fascinating subject to professional provision of services by UK only qualified barristers, general brackets 1. And I can skip through this quite quickly because we've covered off a lot of it. Looking at the TCA, and it's one thing that you should all recall, and I think it was mentioned in one of the morning sessions, it has been renumbered and totally changed in terms of its format, not its content. So rather than the serve-in and everything else, it is all articles running from 1 through to 900 and something. The TCA Part 2, Chapter 3 deals with cross-border trade in services. Article 135, there are no limitations on the number of service providers. Article 136, no need for a local presence. So fly in, fly out, totally possible. This is services, let's not forget, not establishment. 137, no less favourable national treatment, and 138, MFN treatment. All very good and straightforward. Chapter 4 deals with the entry and temporary stay of natural persons for business purposes. And Adrian has dealt with the IPs, and it's not wholly clear, but I think barristers fit more within IPs than anything else, any other kind of concept that's been created under the TCA. Now, one might look, as I'm sure one does, often at Article 143.1 and say, gosh, isn't that nice? There should be, IPs are allowed entry and there should be no quotas or economic needs tests. Well, how wonderful. But one has to look at the annexes, and we'll come to those in a moment. 1432, yes, you can't use your host professional title. There's no entitlement to do so as such, as a service provider. Obviously, as an established practitioner, one can. And 143, subparagraph 4, permissible length of stay, maximum cumulative period of 12 months. Fine. And then we go to the next slide, hopefully. Yes, we do. Then one moves rapidly on to Chapter 5, the regulatory framework, and Evanna has covered off a lot of this. Most importantly, what do designated legal services mean? Well, they mean pretty much everything we all might wish to do, except for the rather critical omission of EU law. So that's a little bit of a blow. You can do English law and public international law, but not EU law. 194, access to supply under the lawyer's home professional title. So Fergus, Randolph, barrister, Adrian Berry, barrister, super, not a problem. And then 196 deals with non-conforming measures. And effectively 194 is, yes, you can supply under a lawyer's home title, but 194 does not apply pursuant to Article 195 and 19. In fact, it's 195. So that's a typo. I'm glad I noticed that. It should be 195. Article 194, in other words, access to supply, doesn't apply to any existing non-conforming measure of a party at the level of, for the Union and for the UK, the various points set out there. And that neatly brings me, if I can move, there we are, to existing measures and other measures. And these can be found in the annexes, and there are many annexes, but annexes 2019 and 22 are the relevant ones for this. Existing measures, so one has to look up, and it's incredibly lengthy annex, this. One has to find one's way through it, and eventually one does. Reservation number 2, professional services, including legal services. Now, insofar as designated legal services supplied under home title, so Adrian Berry, barrister, Belgium, B list. You're back in purgatory again. France, residency or establishment is required in order to practice on a permanent basis. So that's a little bit problematic. Other services, including arbitration, Belgium, residency is required for full admission to the bar. Well, yes, that's absolutely fine. And France is the same. So those are existing measures, and why are they relevant? Because as we saw, essentially Article 194 is subject to them. Now we then move on to limitations on independent professionals, and that is Annex 22. And you probably need to go down to the gym when you're flicking through this, because it's quite a large amount of paper. So limitations on independent professionals, Annex 22, page 1598 of the Official Journal and following. TCA, this is important because you will recall, having all been paying attention earlier on, that one of the earlier articles in the TCA said, no, you can provide your services, no need for economic needs test. Well, subject to Annex 22, paragraph 6 says that in sectors where economic needs tests are to be applied, the main criteria will be in the assessment of, not within the UK, in the EU, the relevant market situation in the member state or the region where the service is to be supplied, including with respect to the number of and impact on service suppliers who are already providing a service when the assessment is made. So you can see it's relatively straightforward for some protectionist professions in certain member states, and I'm not going to name any names, might wish to take advantage of that. Now, as it happens, surprise, surprise, there's no economic needs test for France, but one is applied in Belgium. And of course, in Belgium, in Brussels in particular, there are a large number of practitioners. And so who knows whether and how this provision will be applied. Isn't it nice that the UK has no reservations for legal services? So we have been very generous. And if we thought that generosity was going to lead to reciprocity the other way around, well, let's face reality, shall we? So we'll see. And that's why we're still in the mosh pit. Article establishment, so we dealt with services, establishment, very different. Most barristers will not be established. There are a few exceptions like myself, but most barristers will be looking at the services side. So I'll do those very quickly, not least because I'm very, very seriously running out of time. Article 10 of the Lawyers' Directive got me to where I am today in terms of my tableau presence, because I don't know any Belgian law. And I'm proud of that particular fact. I'm not embarrassed about it because I don't hold myself out as someone who does, but I still have my little Belgian card saying I'm a Belgian lawyer. Perfectly legitimate thing to do under Article 10 of the Lawyers' Directive. Under the 2019 EU-UK withdrawal agreement, recognition of that particular fact prior to the end of the transition period shall maintain its effect. So I'm okay, I'm all right, Jack. And 28, same if you're in the middle of, if you've started, it's the mastermind point, you've started so you can finish. The alternative route, of course, is to take the host state bar exam and become an expert in your host member state's laws. I wish you luck. And then we come to the end, very nearly. Yes, we are at the end. Audience rights in Luxembourg restricted to those lawyers called to the bar of a member state, dealt with that. I tried to make that sign at the end, which is a sort of no entry sign, red, but that was beyond my technical competence. So I apologize for the blue. Ireland, we've seen the issues there, law, sock and bar. Belgium, purgatory. Dante, Lisby. Gebhardt, yes. Gebhardt, and I printed off the operative page, part of the judgment in Gebhardt, that well-known judgment of 1995. A national of a member state who pursues a professional activity on a stable and continuous basis. Those are the words that will be used against UK practitioners who attempt to use their deemed establishment in a member state to practice before Luxembourg, the Luxembourg courts, and hold their privilege rights. And I am aware of at least 2 challenges to UK legal professionals who've signed off on pleadings, and they signed off as Irish lawyers, if you will, and there are challenges to that, and the registry in Luxembourg is very aware of the situation. So again, watch this space. Thank you very much indeed.
Well, thank you. Thank you, Fergus. And thank you. I hope you can see me and hear me.
Yes.
I've still got your slides up on my screen.
Gosh, I'm so sorry, but how do I get rid of them? Right. Ah, splendid. It says new share. Oh, stop share. Good, good, good. Splendid. Good.
Right. Well, thank you very much to you, and thank you on behalf of everyone to each of our panelists for what have been interesting and instructive contributions. They provided a lot for us all to digest. Listeners have been so overwhelmed that nobody, as far as I can see, has raised any question for any of the panelists. I wish all practitioners well in grappling with the issues and problems that have been outlined for them. If you decide to move your focus away from the EU and to exercise practice rights in Kazakhstan, I look forward to welcoming you to the court of the Astana International Finance Center, to which Philip referred in introducing me. Now, in the course of his technical moves at the beginning of this session, he managed to produce on my screen the message, "You have been promoted to panelist." I now hand back to him to be demoted from the panel and to enable him to get ready for the next session. But thank you again to all the panelists. Thank you.
And thank you, Stephen, for chairing the panel, or as they say in Kazakhstan, Urkan Rahmet. So I will once again suspend the session, and then we're going to resume in a quarter of an hour with the final panel of the day about the Northern Ireland Protocol, to be chaired by Lord Justice Green. And everyone can go and have a cup of tea or whatever, and I'm going to spend the time moving the panelists from one place to another. Zoom button. And welcome everyone to the last of the panel sessions today, which is going to be chaired by Lord Justice Green. Nick Green is a former chairman of BEG, but that is not all. He was also chairman of the Bar and of the Advocacy Training Council before going to the bench, and is currently chair of the Law Commission and has been a member of the Court of Appeal since 2018. So Nick, over to you.
Thanks very much, Philip. Well, good afternoon, everybody. Some of you might have been listening in on the conversation that we were all having as panelists in the last few moments. This promises to be really quite an interesting panel session. The Northern Ireland Protocol was intended to be the exception that proved the rule. It is proven to have complications both legally and politically, and in this last session we will be exploring some of those complications. As I think most people know, in its short existence, the protocol has given rise to a row over the government's adherence to international law, political tensions within Northern Ireland, and a great deal of head scratching as to what, if any, implications it might have on the future of the United Kingdom, including for Scotland. It has also, albeit very briefly, made an appearance in a judgment of the Divisional Court handed down yesterday. Now, to assist us in unravelling the implications of the protocol, we have 3 speakers with very different experience. We start with Thomas Liefländer, now with DG Trade, but formerly Deputy Head of Unit for the Taskforce for Relations within the United Kingdom. Thomas not only has a hands-on experience of negotiating the trade relationship with the United Kingdom and the protocol, but he has a distinguished academic record in EU and international law. Thomas will provide a European context very much from the inside. We're then going to move to Denzil Davidson. Denzil is presently an advisor on EU and multilateral issues. As he described it to me earlier, that involves what goes on and why, and the implications for policy. Denzil was formerly an advisor to Theresa May on EU-related issues. He's acted as an advisor to 2 foreign secretaries, and in the EU, he worked within the cabinet of Lord Hill on financial services. So Denzil will provide a broad political context to the issue. We'll then end with Professor Guglielmo Verderami, a very well-known and very distinguished academic and practitioner in international law. His academic credentials have embraced not just King's College London, but Columbia and Harvard universities. Now, each of our speakers will talk for approximately 10 minutes. We would very much like then for the audience to participate, and there are ways and means in which you can express your interest. There is an electronic hand, apparently you can wave at us, or you can just send a message to Philip. But please do feel free to pose questions to this really rather interesting audience. So we'll start with Thomas. So Thomas, over to you.
Thank you very much, Nicholas, and thank you indeed to the organizers of the conference for inviting me to speak here, which I do with pleasure. It's one of the rare treats I have of continuing to speak on Brexit and Ireland, Northern Ireland, after having left the then UK Taskforce, now the UK service in the European Commission. One short caveat before I start, which will not surprise any of you, of course, as a Commission official. You'll be not surprised that all of the views I'll express today are my personal views and not those of the institution. Now, given that I don't currently actively work on the UK relationship, I'll try to not express myself on any of the current debates or discussions that are ongoing, but rather try to use a few minutes to explain how the EU could be described as conceiving of the protocol and how its attitude towards this document has evolved. And in this respect, I want to make 3 fairly short points. So the first one is the protocol is the outcome of very long, very detailed, very exhaustive, and as I can attest, exhausting negotiations. The outcome is a very delicate balance. In very simplified terms, the UK has accepted that Northern Ireland remains aligned with a certain part of the EU acquis, including as regards certain checks and controls on goods entering Northern Ireland from outside of the EU, while in return, the EU has agreed to treat the land border as if it were, for the purpose of trading goods, still a border between 2 member states, rather than what it actually is, an external border of the EU. This balance, if I may say so in passing, is reflected to an extent in the title of the document, which is the Protocol on Ireland, Northern Ireland, and not, as is often maybe in shorthand said to be the case, the Protocol on Northern Ireland. It is about more than Northern Ireland. It's about Northern Ireland in the context of the island of Ireland and the context of Ireland's place in the EU and the single market. So this balance is important, and it strikes me, and I plead for you to forgive me for some inevitable generalization here, that some commentators in the UK, maybe some politicians in the UK, have not quite realized how delicate this balance is from the perspective of the EU, and how far the EU has stretched itself in actually agreeing to this. The perception often is that the EU just imposed what it wanted and the UK had no choice but go with it. But that isn't quite accurate. The balance that was struck was one that is by no means comfortable for the EU nor for its member states. To give you just one example out of many, to think that the EU would ever outsource the administration of its customs border to a third country was, until the negotiations on the withdrawal of the UK, absolutely unthinkable. And I venture to say it will never happen anywhere else ever again. So there are certain elements to this balance where the EU went clearly outside of its comfort zone. And it did so in return for certain commitments from the UK. And having sat personally through quite literally hundreds of meetings with the member states over the course of the negotiations, I can assure you that those commitments by the UK in return for what the EU agreed to do were absolute sine qua non conditions for agreeing to the protocol. And as you remember from the negotiations, agreeing to the protocol was a sine qua non for agreeing to the withdrawal agreement. So I think that in itself should give you a sense of the importance that the EU, and I mean empathetically the EU, not the European Commission. There is that perception that all the position of the EU is driven by some technocrats in the Berlemo, but that is definitely not the case. So the attitude of the EU towards the various commitments was that the EU stretched itself, had agreed to, from its perspective, a very uncomfortable arrangement in return for delivering the objectives that both parties signed up to. But in return, of course, it attaches great importance to the commitments that the UK signed up to in this protocol. This brings me to my second point, which is that the protocol is a detailed, and in the words of the preamble of the protocol, unique solution. And I want to stress that second word, solution, that the EU and the UK have agreed to give in response to the unique challenges posed by Brexit to the island of Ireland. The EU and the UK have agreed that the arrangements set out in the protocol are both necessary, but also sufficient to achieving its objectives. In that sense, again, the preamble speaks of the protocol constituting a unique solution. That underlines that the protocol, by its own terms, provides what is perceived by the parties as a complete response to the unique situation on the island of Ireland, and is not dependent on any future agreements or arrangements. And in that sense, of course, it is distinguished from previous versions, such as the backstop, which was designed as an interim solution to be replaced in time by a different agreement. So to put it in more general terms, the protocol is not the starting point of a conversation of how to deal with the consequences or the challenges of Brexit on the island of Ireland, but it is the detailed response that the two parties found to that challenge. It does not, in that sense, require any rebalancing or renegotiation, but rather an implementation of the balance that was agreed. There are, of course, lots and lots of discussions going on about flexibilities and further derogations and pragmatic or balanced implementation that continue. None of those discussions, of course, are entirely new. Many of those elements that are currently being discussed were discussed in great detail during the negotiations, and some of the flexibilities and derogations found their way into the protocol. We can speak about those in detail if you'd like. Whereas many others did not, simply because they were not acceptable to one side or the other. And of course, at the end of the day, both parties accepted the protocol as it now stands. So against this backdrop, I think you might find it easier to understand why the EU is now reacting with a certain degree of reluctance to proposals for further derogations, further flexibilities, be it on SPS controls, be it about ideas of extending the goods at risk scheme to areas other than customs duties, etc., etc. Those were things that were discussed and discarded as not allowing for the balance to emerge that eventually allowed the conclusion of the protocol. If we had been willing to accept those flexibilities and derogations, we could have done so in the negotiation. At that point, and I repeat my previous point, the EU considered that the commitments in return for the agreement were absolutely essential, and we were not willing, the member states were not willing, the Commission was not willing to accept anything less. So against that backdrop, I think you won't find it so surprising that now coming back with some of those same ideas will not receive the warmest of welcomes. Which brings me to my third point, which is that in the discussions in the UK, inevitably and fully understandably, don't get me wrong, the focus has been on the burdens that the protocol imposes, in particular on East-West trade. But in that focus on some of the burdens and the challenges, it may have lost some sight of the significant benefits and the opportunities that the protocol also provides. It does place Northern Ireland in an absolutely unique position with unparalleled and unprecedented access to both the EU single market as well as the UK's internal market. It underpins the all-Ireland economy, North-South cooperation, and of course, it successfully avoided and continues to avoid any need for a hardening of the border between Ireland and Northern Ireland. These benefits are there to be seized, and personally and from the side of the EU, we certainly do hope that they are seized to their fullest extent so that Northern Ireland, its people and its economy benefit from those opportunities to the maximum. However, they are part, as I said, of a delicate balance. So if the UK cannot or will not live up to its commitments under the protocol, how do we ensure that that balance is maintained? You cannot assume that the one side, namely the EU commitments, are done and dusted while trying to re-engineer and renegotiate the other side of the coin, which is the UK's commitments. So to conclude my short intervention on this point, it's obvious that the implementation of the protocol poses absolutely massive challenges. That is undeniable, but is also not surprising. It needs to be taken seriously, that is clear. It is also clear that Brexit has consequences. And I fear I'm just echoing my old boss, Michel Barnier, here when he pointed this out. Brexit has consequences. And in the protocol, the EU and the UK agreed on how to address those consequences in the context of the island of Ireland. That must now be given effect. Many of the current challenges that we are seeing are consequences of Brexit that are to be addressed through the protocol. They are not, if you allow me, consequences of the protocol. They are consequences of the operation of the protocol in the context of Brexit. And on that note, I'll close my short intervention. I'm looking forward to the discussion and any questions you may have.
Thank you very much indeed. That was fascinating. So massive challenges. Brexit has consequences. Denzel, from a more domestic perspective, how are we meeting those challenges and those consequences? Is it a good deal?
Well, I was going to try to look at the sort of the history, set it in history, and take through to where we are now. And I obviously must make it clear at the start that I am not a lawyer, so I'm not going to try to give a legal analysis of the protocol. I wouldn't dare to do so in front of this audience. I think it's useful to start off with two facts: the Belfast or Good Friday Agreement and Brexit. Now, the Belfast Good Friday Agreement is, of course, a complicated instrument, and there are some points of how it brought peace to Northern Ireland that are particularly relevant to Brexit. First, it allowed people in Northern Ireland to live and identify as British or Irish. Second, crucial to the agreement is the notion of parity of esteem between the two main communities in Northern Ireland. Third, the agreement is a delicate balance of three strands: power sharing within Northern Ireland, North-South cooperation between Northern Ireland and the Republic of Ireland, and East-West cooperation between the Republic of Ireland and the United Kingdom, but felt also to cover the ties between Northern Ireland and Britain. Both the latter strands matter because, of course, both the Unionist and Nationalist communities feel themselves part of a larger self, the United Kingdom and the Republic of Ireland, respectively. Now, Brexit creates a serious problem for Northern Ireland and its peace process in three principal ways. The first is that potentially Brexit can mean a border, not for people, but for trade. In Northern Ireland, trade is not just about economics, but about identity and belonging. Trade barriers between Northern Ireland and either larger entity make a community feel cut off from part of themselves. Although the agreement does not depend on EU membership or rule out a border for goods, it presumes EU membership's effects: no border for goods east-west or north-south, creating a sense of borderlessness with both communities' larger selves. Second, the success of the peace process has depended on close cooperation between the British and Irish governments. The United Kingdom's departure from the EU creates a potential serious divergence of interest between the two. They no longer sit on the same side of the table, as it were, but opposite each other. The third is the problem of consent. The majority in Northern Ireland and a big majority in the nationalist community voted against Brexit. Consent, it must also be said, has not been sought for this protocol within Northern Ireland, and a clear majority of the nationalist, of the unionist community at least, are opposed to it. Now, the Prime Minister I served sought to solve these problems by establishing a deep and special partnership with the EU to avoid too conflictual a relationship between the EU and the UK, and by negotiating a relationship with the EU which would have ensured no border for goods for Northern Ireland, either with Britain or with the Republic of Ireland. That effort failed because although the political declaration we agreed pointed to no trade border for goods between Northern Ireland and Britain, it did not guarantee it. And although the backstop we negotiated ensured no customs border between Britain and Northern Ireland, it did not guarantee no regulatory or VAT border. And because the EU could probably lock Northern Ireland into, theoretically at least, into a relationship where there was such a border, the DUP rejected it. And their rejection was crucial in making it impossible to assemble a parliamentary majority for Theresa May's proposed manner of Brexit, and consequently she lost office. We might note in passing that the DUP, by backing Brexit with little thought to the consequences, and by rejecting a path to a softer Brexit, ended up with nearly the worst outcome they could have done for their and their community's interest. It will be a lesson for the ages in how not to do politics. The current government, on the other hand, accepted a border for goods and customs, VAT and regulatory checks and controls between Britain and Northern Ireland in exchange for potentially complete sovereign autonomy from the EU in Britain. The political cover they secured in the version of the protocol they negotiated in Article 18 was a consent procedure, so that if a majority of the Northern Ireland Assembly voted against the economic parts of the protocol, they would ultimately fall away. Now, we can look forward to this point playing a big and highly polarizing part in next year's Assembly elections. I'm afraid it has also to be said that current ministers have not been honest in admitting what they negotiated, signed and voted for in Parliament. From the Prime Minister downward, they have claimed that there would be no border in the Irish Sea and there would be no checks and controls. The protocol's text requires both. They have not told the truth is a major contributing factor to the collapse of trust between the British government and the EU. The core interests the EU have sought to secure in their approach to the protocol, at least seen through British eyes, is first the protection of the integrity of the single market, and second, the protection of the peace process. The latter is usually expressed as the prevention of a hard border, that is, checks and controls for goods on the island of Ireland. That has been achieved by creating a hard border between Northern Ireland and Britain. And this is the classic problem of being unable to have one's cake and eat it. That border, in principle, is just as much a problem for the peace process as a border between Northern Ireland and the Republic. Unionists believe that this protocol does not recognise the parity of esteem and that is set out in the Belfast Good Friday Agreement, and prioritises North-South relations over East-West. And they have a point. We've seen the natural effects: deep anger and alienation in much of the unionist community, which was a major but certainly not the only factor in the recent riots. The problem is that if the UK and the EU have a structurally distant relationship, as they currently do, then the objectives of protecting the integrity of the single market and the achievements of the peace process are in some contradiction. Now, there are two ways we can at least try to ameliorate this problem. The first is by having a closer UK-EU relationship, and that in one important area is what the Commission is now proposing: to do away with agri-food checks, a major issue if the UK adopts the EU's agri-food rulebook. This British government currently rejects this because it would constrain their ability to conclude free trade agreements, and because they don't want to be a rule taker. From my point of view, there is an irony that the Commission are now offering something this British government doesn't want, which they refused to offer the previous government in a UK-wide backstop, which very much wanted it. The other way to ameliorate the problem is to manage the regulatory border with greater flexibility, which is what the British government now wants. Analogous to the customs arrangements, they seem to want goods allowed from Britain to Northern Ireland to go without controls if on a reasonable assessment they are not at risk of moving into the EU's 27th market. The EU currently seems to reject this, as well as a New Zealand-style agri-food equivalence agreement, which would go some way to reduce, but by no means all the way, introduce checks and controls as too great a risk to the single market. Now, although much of what the British government is asking for is not provided for in the operative parts of the protocol, they do point to Article 6.2 requiring best endeavours to facilitate trade between Northern Ireland and other parts of the United Kingdom, and to the force of the recitals or the preamble, including the protection of the Belfast Good Friday Agreement in all its parts, avoidance of impact on everyday life, and Northern Ireland's integral place in the UK's internal market. So we are at an impasse. Meanwhile, the marching season, traditionally a time for public disorder, is less than 2 months away. The power sharing arrangements have become much more fragile. There is minimal trust between the UK and the EU. The EU see that British ministers have not told the truth about what they agreed to, and that they have proposed breaking their commitments in last year's internal market bill. That's leaving aside the legal controversy over the unilateral extensions the British government has undertaken to phase in measures. They hear ministers claim that consequences of the protocol written down in black and white were not foreseeable. So even when the British side have a point, their credibility is reduced. On the British side, the government thinks that the EU does not understand that they have in effect made themselves part owners of a peace process. And from their point of view, the EU's priority in the protocol's implementation seems to be the furtherance of the EU's interests, rather than fostering peace and stability in Northern Ireland. The UK government believes that the EU does not understand that the British actions are driven by the need to preserve peace and stability. So I'm afraid, unless something changes, we are on the path to more disputes between the UK and the EU and a worsening of the political situation in Northern Ireland. And this in turn will damage the already weak overall relationship between the UK and the EU. So in summary, although the protocol attempts to be a solution and proclaims itself to be a solution, given the problems and where we are, it is an answer, and an answer is probably better than no answer. But I'm afraid in terms of something that is working for Northern Ireland, we are not there.
Denzel, thank you very much indeed. Our final speaker, Guglielmo, is going to impose some legal order on what Denzel has described as an impasse. So over to you. Where does rationality and legal solution arise in this mess?
Well, thank you very much, Sir Nicholas, and to my co-panelists for their very powerful and robust presentations. Let me say at the beginning that, like a number of people at the conference, and in fact like Thomas as well, I too have had some professional involvement with matters relating to UK-EU legal relations, and what I'm saying reflects exclusively my personal views. So I was going to use my 10 minutes to discuss certain aspects of the protocol as a treaty, and these are the aspects that I think are acutely relevant to the discussion of the wider political and policy considerations and challenges around the implementation of the protocol. And the starting point, it seems to me, is to just focus on the object and purpose of the protocol. The object and purpose of a treaty is important, of course, because under the general rule on treaty interpretation, a treaty must be interpreted in good faith in accordance with the ordinary meaning of its terms in their context and in the light of its object and purpose. And a famous international lawyer in the 1960s put the exercise of treaty interpretation quite nicely, Daniel Patrick O'Connell. He said the challenge with treaty interpretation is to ascertain the logic inherent in the treaty and then to pretend that that's what the parties desired. So where does one find the logic of the Northern Ireland Treaty? And we've heard, in fact, from both Thomas and Denzel that it's a complex arrangement with some very serious compromises, with both parties going out of their comfort zone. The place where one would normally start with treaty interpretation in distilling the object and purpose is the preamble, and we've heard already some references to it. I would just note that the preamble to the Northern Ireland Protocol is a very long document. It runs to 24 paragraphs. It's longer than the preamble to the Withdrawal Agreement itself. And the Northern Ireland Protocol consists of only 19 provisions. But in addition to those references in the preamble, the protocol also, quite helpfully, contains a provision, Article 1, entitled Objectives. And Article 1 consists of 3 paragraphs. The first and the third paragraph deal with the Belfast Good Friday Agreement, to which I will come in a second. The second paragraph does not mention the Belfast Agreement. It provides simply or that this protocol respects the essential state functions and territorial integrity of the United Kingdom. And some of you may have noticed that this language of essential state functions and territorial integrity is language that appears also in Article 4.2 of the Treaty on European Union. That is the provision that is amended by the Lisbon Treaty, gave considerable weight to the concept of national identity and self-government and essential state functions. And it's a provision on which there has been quite extensive debate, and I think there has now also been some reliance on this provision in the jurisprudence of some domestic Supreme and Constitutional courts. And I'm sure it is a provision that will continue to give rise to interpretation and application by domestic courts and potentially at the European level too. But of course, the context of Article 4.2 of the TEU is entirely different and cannot really give much support for interpreting Article 1.2 in the protocol. But let me go back to the Belfast Agreement paragraphs. The first paragraph of Article 1 simply provides that the protocol is without prejudice to the provision of the 98 agreement and to the principle of consent. The third paragraph is the one that adopts more clearly the language of an objective or a purpose, and it provides that the protocol sets out arrangements necessary to the unique circumstances on the island of Ireland and to maintain the necessary conditions for continued North-South cooperation, to avoid a hard border and to protect the 98 agreement in all its dimensions. So the protection of the 98 agreement is if not the central purpose of the Northern Ireland Protocol. The protocol is the means that the parties have agreed would allow them to pursue that end. And it has to be interpreted and implemented in light of that central purpose. By the 1998 agreement, I think this is not controversial, the protocol is referring not just to the bilateral agreement, the sort of pure treaty aspect of the 98 agreement between the UK and Ireland, but also crucially to the longer and more detailed agreement reached in the multi-party negotiations, which obviously the UK and Ireland then in the bilateral annex endorse. The 98 agreement is a very different legal creature from the Northern Ireland Protocol, and it's really difficult to understand, I think, the Northern Ireland Protocol without really getting into the 98 agreement. But it's quite a different instrument. It doesn't feel in parts like a lawyer's text in the same way as the protocol does, and that is due to its origins and the way in which the multi-party side especially was negotiated and agreed. It is certainly not a peace treaty in the sense in which the Treaty of Versailles was a peace treaty. In some ways, perhaps it is more like the treaties of Westphalia in the sense that it was designed to create constitutional structures that were aimed at maintaining peaceful coexistence and avoiding a return to intercommunal violence. So to cite O'Connell again, we need to understand this very complex logic of that agreement. And Denzel has said a few words about the parity of esteem and the binational recognition. We need to understand the complex logic of that agreement in order to understand the logic of the protocol. And this is the exercise that the parties, the UK and the EU, should be guided by in interpreting and applying the protocol. Now, the protocol also has a rather elaborate dispute settlement structure. And the key provision here is Article 12.4 of the protocol, which provides for the jurisdiction of the CJEU on the same basis as under EU treaties as regards 4 key provisions of the protocol. Article 5, which deals with customs and movement of goods. Article 7, which deals with technical regulations. Article 8, which deals with VAT. Article 9, with the single electricity market. And Article 10, which deals with state aid. I think I said 4, but there are 5 key provisions as regards to which the CJEU has jurisdiction on the same basis as it would have under the EU treaties vis-a-vis member states. So these are the provisions in the protocol that enable and mandate the application of some EU law to Northern Ireland, albeit in a very different context, as we've heard from the other contexts to which EU law applies. It is not a context of membership, but it is one that is defined by the unique circumstances of Northern Ireland and the need to preserve peaceful coexistence under the Good Friday Belfast Agreement. I think even if you look at the provisions over which the CJEU has jurisdiction on the same basis as the EU treaties, there are some interesting and complex aspects. So, for example, Article 7.1 refers to UK law, but it is at the same time a provision as regards to which the CJEU has that extensive jurisdiction. But perhaps more importantly, there are some key provisions within the protocol that fall outside the subject matter jurisdiction of the CJEU as defined under Article 12.4. And those provisions, quite importantly, include Article 4. Article 4 is the provision that says that paragraph 1, the Northern Ireland is part of the customs territory of the UK. Now, of course, you have to read Article 5, which follows from Article 4, and Article 5 takes away, in some important measure, what Article 4 appears to concede. Article 6 on the protection of the UK internal market is also one of the provisions that falls outside the subject matter jurisdiction of the CJEU under Article 12.4, and Article 16 on safeguards clauses. But of course, the withdrawal agreement, the main withdrawal agreement, the protocol is an integral part of the withdrawal agreement. It's a provision in the withdrawal agreement that specifies that. But the main text of the withdrawal agreement has its own dispute settlement mechanism, and that is set out at Articles 167 and following. An arbitration panel constituted in accordance with those provisions would potentially have jurisdiction in respect of a number of disputes arising under the protocol. Depending on the nature of the alleged breach, there may be concurrent jurisdiction situations with both the CJEU and the arbitration panel having jurisdiction in whole or in part over that dispute. Now, of course, a dispute on the implementation of the protocol doesn't need to end up in litigation. In international law, there is a big debate open as to whether resort to litigation ends up escalating the political dispute or lowering the temperature. I tend to be in the latter camp in that debate, but in any event, the protocol provides for a number of non-judicial mechanisms and processes through which disputes can be addressed. There are at least 3 treaty bodies under the protocol that have a role in the implementation of the protocol. And then, of course, you have the treaty bodies created by the Good Friday Agreement, which are referred to in the protocol. The most important of these treaty bodies is the Joint Committee, as we all know. In respect of certain areas under the protocol, the Joint Committee has the power to adopt decisions that have the same legal effect on the parties as the withdrawal agreement and the protocol itself. And the implementation of Article 5 in particular was subject to a number of binding decisions that the Joint Committee had to adopt and which were adopted in December 2020. And also crucially, Article 13.4 of the protocol requires a decision of the Joint Committee in order to extend new EU law to Northern Ireland. So the application of new EU law is not automatic unless it amends or replaces existing EU law already applicable to Northern Ireland. But new EU law within the scope of the protocol would require consensus within the Joint Committee. And of course, if it becomes difficult to keep Northern Ireland aligned with new EU law, that sui generis nature of the arrangements in Northern Ireland would increase. And I think finally, just on the interpretation of the treaty and on its sort of continuing life, like any other treaty, this treaty too must be interpreted in light of any subsequent practice of the parties and any subsequent agreement which the parties reach as regards the interpretation of the treaty. And I note that in December 2020, the parties decided to reach agreement on certain, on delaying in certain aspects of the implementation through the mechanism of parallel unilateral declarations. That was the sort of December treaty method that was agreed for dealing with some of those problems. But of course, what happened in March with the unilateral declarations is a different situation because there was no parallel unilateral declaration from the EU in that case. I think I will stop here. Forgive me, I may have taken a couple of minutes longer than the time allocated to me.
Thank you very much indeed. That was fascinating. Now, I think we now have some time to throw this open to the floor for questions, and take that. If we don't get a question, I've got one question which I'd like to ask Thomas in light of that analysis. But let's see if there are any comments or questions, observations, or anything from panelists or from the floor, from the audience.
There's one from Daniel Beard, actually, in the.
Ah,
yes.
So, right, from Dan. Where's it come up?
I can read it out. I think it's in that little Q&A box.
Yeah, I've got it. Okay, it's from Dan. Dan says the new DUP leader has spoken very warmly about the protocol and threatened legal action. What advice would the panel give him about the protocol and challenges to it? This sounds a bit like the sort of question you get on Gardner's Question Time. So, panelists, what advice do you give to the leader of the DUP? Who's going to have a go? I think Denzel should start with this one.
I can't give him legal advice. I suspect he will not be on strong legal ground. I mean, the problem of the protocol is with the spirit of the Belfast Good Friday Agreement, rather probably than the letter, but others will have a better view. I think he can do two things, I think, probably, to start to dig himself out of the hole the DUP have dug so strenuously. The first is to try to win a majority at the next elections in next year for the Unionist side, but that is possible, but as things stand, unlikely. It isn't the biggest problem, by the way, at the next election. The biggest problem at the next election is that because of the splintering of the Unionist vote, rather than any increase in the nationalist vote, Sinn Féin are likely to be the largest party, and that will entitle them to the first ministership. And it is extremely unlikely that the Unionist side would consent to that. So power sharing is in grave peril thereafter. The wiser thing, perhaps, would be for unionism to have a very serious think about what kind of overall UK EU relationship is in their best interests. And I would suggest to them that a closer overall UK-EU relationship, or still more radically, something more like what we had before 2016, served unionist interests better. But that would require a great deal of painful political self-interrogation and some admissions that people might not want to make, and would not necessarily make life easier for them in the short term. But my governmental and political background, you've got a governmental and political answer.
Thomas, Guglielmo, do you want to come in on this?
I think I may be conflicted on giving legal advice to the leader of the DUP, so I'm not sure I can answer that question. But I can perhaps make a sort of wider comment, which goes back to something that I think both Denzel and Thomas have said, namely that by means of this treaty, the EU and the UK have agreed to own the unique problems of Northern Ireland. And that means owning the problems of the nationalist community and of the unionist community. And I think it is very important for the unionist community, insofar as that sentiment of alienation is developing vis-a-vis the protocol, to be able to communicate that effectively to the EU as well as the UK, because they're both part of this picture, and Ireland, of course, by virtue of the 1998 agreement. But I think they have certain positions and interests under the Good Friday Agreement, and they should talk to both parties, as it were.
Thank you. The 2 points have come up on the chat. One from Evanna, which says "whither now then." I'm still trying to work that out. But Nick Ford, who's very clever, has provided an answer, and I'm going to ask Nick to come on screen and explain it, which is following the analogy with GQT. The answer must be stop digging. And I think, Nick, if you're lurking there in the audience, can we get Nick up and Nick can explain that answer? Nick, you're now up but on mute.
Unmute. And I'm here. Right. Excellent. Well, that has been absolutely fascinating, I must say. Yes, it's really echoed in the what I had in mind is already been echoed in the answer that's been given. In some ways, watching from afar, it seemed to me that in some ways the Northern Ireland Protocol, or the Northern Ireland Protocol, as we're reminded it must be, could have offered some really attractive possibilities for Northern Ireland, being at the same time within the UK and being able to supply the UK with relative ease, but also being within the EU for certain customs purposes. And so rather than digging, I would have thought that there must be reasonable opportunities there, which would be good for Northern Ireland as a whole. But as I say, I'm a long way from the detail of this, so I'm just listening with fascination to these contributions.
If I might reply to that.
Yes.
I think the problem is, the problem is it's not one of detail. The problem is one of feelings of identity and belonging. And the point that Northern Ireland has unique opportunities under the protocol. That is completely true. But it's a bit like offering someone a large helping of chocolate cake. They say, I don't want chocolate cake. I want my meat and veg, thank you very much. And the unionist community is not interested, most are not interested in the economic opportunities currently, may change in the future. What they want is no diminution to their sense of Britishness. And that is the problem we are stuck with. And the debate, even the DUP started off the year trying to talk up the opportunities of the protocol, but they found, because of actually bottom-up pressure, to be fair to the DUP, that was not working. Anyway, we'll all see how this works out in the politics on the ground in Northern Ireland, but I fear I'm not very optimistic.
I'd be interested in any of the panelists' view, and Nick, since we have him up on the screen, so whether the dispute resolution mechanisms, plural, that have been identified might, in the fullness of time, as perhaps political heat diminishes, actually provide a solution to some of the issues which are arising. We're still very much in the early days, the initial days of the protocol. I don't know if Thomas has got a view on it. I mean, you may be part of negotiating that dispute resolution mechanism, or that suite of mechanisms.
Yes, thank you. I tend to share Guillermo's view that taking a dispute to a judicial forum or to a legal forum tends to take the heat out, and some of that I think we will come to see. However, it does depend on the extent to which we are in a situation where the approaches and attitudes of both sides are too cross, quite simply. I think it's possible to settle quite a lot of disagreement over how exactly this particular regulation has to apply, or what the timeline is for that one, or what have you. That's certainly clear. Where the attitude is with respect to certain things, well, that just can't work, that has to go, then I think we're in a different scenario, and I'm not sure whether simple dispute resolution will help, because it seems to be, and I think there I echo some of the things that Denzel said, it seems to be less about what precisely is the legal obligation. That's of course what you solve through dispute settlement, but rather, as I think Lord Frost himself said a few days ago, well, the problem is that we signed up to it in the first place, and that you will not solve through dispute settlement. If I can maybe throw a highlight but rather pessimistic note on how far dispute settlement can solve some of the more fundamental issues.
Thank you. Does anyone else want to come in? Does anyone share that pessimism, or is anyone optimistic? is this really not a matter for judges and lawyers? It's a matter for politicians really to be compelled to get round the table and find solutions.
If I may sort of add to my plethora of pessimism, I think in a nutshell, my personal view is that the British government and the EU had signed up to a legal instrument which cannot be implemented in Northern Ireland without severely endangering stability there. And it is both perfectly true that the British government has a lot of obligations which legally it ought to be undertaking, but it is also true that were it to do so, then we would probably see a return to the rioting we saw earlier, and in time maybe something worse than that. And that the British government certainly should have known and thought about these things before it signed it, and maybe others should have as well.
If I may, Nicholas, if you allow me, add to that, and this of course connects to a point that Denzel evoked earlier, is that the protocol sits there as a separate legal text as part of the withdrawal agreement, but of course the way it plays out in practice and in reality is very much embedded in a broader relationship. And there is in fact a quite telling article, or rather a paragraph in the preamble, that is a survivor from Theresa May's version of that document from the backstop, which speaks about the desire to avoid, to the extent possible, controls at ports and airports in Northern Ireland, to the extent possible in accordance with applicable legislation, and taking into account the respective regulatory regimes. So this document was negotiated and designed to sit within a broader framework. So it may well be that within the current framework and within the current choices of the UK government, some of these challenges are very, very difficult to address. But then maybe I submit to you, the problem is less with the protocol and more with the environment in which the current government decides to situate it.
I could just add a couple of points. The first one is that the language that Thomas has just referred to actually appears in Article 6.2 as well, which provides that the Joint Committee shall keep the application of this paragraph, that's the provision of the protection of the UK internal market, under constant review, and shall adopt appropriate recommendations with a view to avoiding controls at ports and airports of Northern Ireland to the extent possible. And it's one of a number of provisions of the protocol that suggests that this is a living instrument. This is work in progress. And for better or for worse, the parties agreed that the solution to the unique challenges of Northern Ireland was to be found in this document with its processes. And they have to really try to make that work. There is enough process in it by way of political dialogue, by way of dispute settlement, by way of interpretive flexibility that can allow the parties to reach solutions that will preserve the Good Friday Agreement in all its dimensions. I think Denzel is perhaps a bit too pessimistic when he says that the implementation of this protocol will endanger peace in Northern Ireland. He may be right, but the parties took a different view when they agreed this protocol. They took the view that this protocol was not going to endanger peace in Northern Ireland, and I think they both owe it really to each other and to Northern Ireland to do their best to make it work.
Yeah, well, thank you very much. That's probably an appropriate moment with a hint of optimism to the effect that the UK and the EU are both arch negotiators, and that maybe a solution will be found, that this is a living instrument which will lead to that solution. So that's probably an appropriate end point for this session. Can I thank you all very much indeed for your contributions, and to those from the floor who have asked questions, and hand it back to Philip. Thank you.
Thank you, Nick. And thank you, everybody, for what I think has been a fantastic conference, high in intellectual and legal content, on some of the most burning issues, from the new regulatory regime that Clare Brodie talked about, to the mechanics of the TCA, really the heart of the new UK-EU partnership, and seeing the future in competition law and the digital economy, seeing our future as far as the provision of cross-border services is concerned, which is of course of immediate and direct personal and professional interest to all of our members. And the fascinating discussion at the end about the Northern Ireland Protocol, in which there is of course a live dispute between the UK and the Commission, and we will have to watch this space. In some ways, this format of the remote online conference assists in focusing on the intellectual content, on the legal content of the programme. It is nonetheless not a suitable substitute for the unique atmosphere of big conferences that we've been used to. And I strongly hope that next May we will manage to reconvene in some suitable place around the continent of Europe to celebrate our next annual conference in person. We have today, over the day, had over 100 unique attendees. At any one time, it rose to roughly 84, but there was a certain turnover, as is normal at these conferences, in the course of the day, and that's great. And I hope very much that we will have over 100 attendees next year, wherever it may be, and we will think about that and let you know as soon as we're permitted. So thank you all, and now we must all, no doubt, rush off and support our